All right, welcome everyone to the final meeting of the Joint Judiciary Committee. We've got a good busy agenda for today and tomorrow. Thank you for making time to join us and to participate. We will follow the agenda as it's outlined. We'll be taking, if you looked at it, plan is to take action on interim topics, the bill topics tomorrow. To work through the process today and get information and kind of flesh this out a little bit. But as far as hard votes, the intention is to get to that tomorrow. I don't believe we'll.
No, we have some today.
We have some today.
The Judiciary.
Anyway, if you'll address your comments to the chair, and we'll just work through this as we go along. We want to welcome Justice Fox. Thank you for joining us today, and Judge Day and Tyler and Blumel. And Commissioner Henry. I think we've got everyone and it's here. It's going to be it'll be a good day. And with that, Tori.
Take a roll call. Senator Anselmi Dalton. Here. Senator Hicks.
Here.
Senator Kinski.
Here.
Senator Nethercott.
Here.
Representative Beitman.
Here.
Representative Jennings.
Here.
Representative Olson. Representative Pelkey.
Here.
Representative Pinnell.
Here.
Representative Salazar.
Here.
Representative Stith.
Here.
Representative Winters.
Here.
Co-Chairman Kirkbride.
Here.
Co-Chairman Christensen.
Here.
A quorum. Senator, Mr. Chairman, I'd also just point out that we are live streaming with video so that both the audience and the committee is aware of that. If you have a private conversation, make sure that you're away from the microphone and that your microphone is turned off. You press the button, the red comes on, and that should broadcast your voice. Please do press the button so that we can all hear and that the video will broadcast that across the state. With that, Mr. Chairman, I think that the next agenda item is the approval of the September minutes.
All right. And with that, on the September minutes, everybody had a chance to look at them. We have a motion on the September minutes. We have a motion, Senator Kinski, Representative Pelkey seconded on that. Any discussion, changes, corrections on the September minutes? With that, all in favor, say aye.
Aye.
Any opposed? Thank you. All right, on to guardianship. Tori.
Mr. Chairman, I'm going to hand that over to Staff Attorney Brian Fuller. But before I do, I should introduce the folks at this table. Kyla Spencer is a staff attorney. She'll be participating later this morning in some of the bill discussion or introduction. To my left is Mary Beth Oatsvall, staff with LSO. If you have questions about any of the hard copies, please see her. She's our expert on making this meeting work smoothly. I'm Tori Racinas, and turn it over to Brian Fuller.
Brian.
Mr. Chairman, good morning. Brian Fuller, Legislative Service Office. Just by way of overview to recap where the committee's been, the committee has considered this issue of guardianship and de facto custody at both prior meetings this year and at its final meeting of the last interim. At the last meeting, the committee heard from two speakers who focused on the best interests of the child and the child's attachment to the guardian. The committee reviewed 19 LSO 26 version 0.5. That's 201 in your binders. This bill draft would allow courts to consider various factors when a parent moves to terminate a guardianship. The bill draft would also allow courts to enter various orders related to the termination of that guardianship. In addition, Mr. Chairman, in your materials, 2-02 is a memo I prepared. A lot of this information should be familiar. It repeats what I've discussed in previous memos in terms of an overview of U.S. Supreme Court precedent on guardianship, on parental rights, as well as the Wyoming Supreme Court's interpretation of our guardianship statutes. The language provides that the court may appoint a guardian if the allegations of the petition as to the status of the proposed ward and the necessity for the appointment of a guardian are proved by a preponderance of the evidence, and the court has held that the Supreme Court has held that a district court can only appoint a guardian upon a finding of necessity, which the court has interpreted based on U.S. Supreme Court case Troxel to mean that a parent is unfit. Mr. Chairman, I'll direct your attention in the memo to page 5. I have expanded a bit on the Supreme Court's discussion in a case Enri SRBM to provide an outline of requirements that would need to be followed for the termination of a guardianship. If a parent seeks to terminate a guardianship, she must prove that the guardianship is no longer necessary. The court has suggested that if a parent was found unfit, that the parent must prove that she is fit, or otherwise the parent must establish that the guardianship was no longer necessary for the reasons that had been established. And then if a fit parent does establish that a guardianship is no longer necessary, the parent would be presumed to be the child's guardian, and the guardian must then rebut that presumption. Mr. Chairman, beginning on page 6 is information from other states regarding their a broad survey of other states' guardianship statutes and how their courts have interpreted those statutes in light of Troxel, among other things. And I think, just to kind of cap that, each state views guardianship in a different way in terms of is the focus more on the children or the parents? But that information, Mr. Chairman, I'm happy to go into further detail. But suffice to say, I think it's up to this committee to decide, how in terms of considering this bill draft, what interests it chooses to put forward. One more thing about the bill draft, Mr. Chairman. It is unchanged from the last meeting. So this bill draft that's before you is identical to the one the committee considered at this last meeting.
Okay. Committee, any questions of staff at this point? What I intend to do is work through the agencies and public comment, and we'll come back to the committee. But
Chairman,
so far, Senator Kinski.
I wonder if Mr. Fuller might give a comment on it's an excellent memo, by the way, and thank you to staff and to Mr. Fuller for that. It's very well done. And I agree with the framework that he outlines on page 5. I think it's not only what the Wyoming Supreme Court would require, but I think it's what the U.S. Supreme Court would require. He does highlight that there is, going a little bit out on a limb to suggest that we might change the presumption one way or the other. But I wonder if he might offer comment on the framework that he outlines on page 5 and how that is or is not reflected in the bill that we have before us, the 0.5 version of the bill.
Okay, Brian.
Mr. Chairman, Senator Kinski, I would first direct the committee to page 4, lines 10 to 13, subsection B of the newly created 331107, and this provides that the court may consider the factors in subsection A, which are various factors related to the parent's situation as well as the child's. But it provides that the court could consider those factors without first making a finding of parental fitness or a finding that the guardianship is no longer necessary. I think that, Mr. Chairman, that subsection could exists within that framework. I think ultimately it's a question of policy, though, for the committee to decide how it wants to approach that.
Tori? Oh, they're chatting. Senator Kinski, does that answer your?
No, Mr. Chairman.
And Mr. Chairman, the other point I guess I would raise is in subsection A, and maybe this would get more, I think this would more directly implicate this framework that I've outlined on page 5. But on page 2, lines 1 and 2, the bill draft provides that the court would consider these factors upon the filing of a petition for termination of a guardianship by a parent. And Mr. Chairman, one suggestion I could offer to tie in this standard, this discussion from Henry SRBM, is to make clear that the factors would be considered upon the filing of a petition for termination of a guardianship by a parent who has been adjudicated unfit. I think the committee may want to consider doing that insofar as it would bring in this question of unfit and would allow those factors to be considered, as part of that question of fitness.
Okay. Any other questions? Yes, Senator Kinski, follow up.
So thank you for that, because, and again, this would be for Mr. Fuller, for Mr. Racina's, on lines 2 and 3 of page 2, the lead off is consider the best interest of the child without first having a threshold determination of fitness or unfitness. The balance of the factors seem to make it a horse race as to who's got the better home, the guardian or the natural parent, and that's not the test. I mean, if that parent meets that constitutional threshold of fitness, they may not be the best parent compared to the guardian, but they're still the parent, and they have the right to that child. So in my view, I guess I'm seeing this. I like the idea of a two-prong approach. First, let's look at the situation where the parent's been found unfit, and now the judge is taking a hard look at whether dad has really overcome his drug and alcohol issue or whether this is just a brief rebound, as opposed to the other situation where dad or mom voluntarily relinquished. There wasn't a lack of fitness, and I don't think the bill gets us there. And I may be missing something, but I just wonder if staff could tell us whether they really are seeing that framework of page 5 of the Fuller memo incorporated into this bill clearly.
And anything else at this point from staff? One of the things we can do is we work through the conversation with both agencies and the public. Some of these questions may either be highlighted or answered. And then we come back around with committee discussion also. But at this point, Brian or Tori, anything you want to add relative to that at the moment? Senator Kinski.
Mr. Chairman, I guess the only thing that I would add to address Senator Kinski's point, and that is well taken, and that's been the struggle with formulating the bill and the memos. We have disparate interpretations of the impact of Troxel across the states. Wyoming's current law is based on the existing guardianship statute and the term necessity. The legislature in the first instance has the ability to change the statutory framework for guardianship. This is an attempt to do that. Clearly, whatever the legislature does, takes the first stab at the constitutionality, passing a constitutional bill, could be subject to review under SRB and under the framework that the Wyoming Supreme Court has determined that those cases under Troxel. So I think that it's important to understand that the statutory framework is the starting point for those MEO and SRB cases. Changing the statutory framework may or may not change the outcome from the Wyoming Supreme Court, and we're not in a position to make that prediction. I think Mr. Fuller's suggestion of in lines 2 and 3 on page 2, placing the adjudication of unfitness helps that question because you then start from the position where a parent has been adjudicated unfit. But all that being said, that this is all information for the committee to make a policy determination and make that determination about constitutionality in the first instance, which, as Brian's memo points out, first lies with the legislature, then the governor, and then, of course, the courts.
Okay. Thank you. Other cut? Anything at the moment? All right. Any other questions of staff so far? All right. With that, let's open this up to input, and we'll start with our agencies. Offer the first round, if you'd like to at this point, to the judiciary. Like you're on your own, Judge Day. Oh, could you pull the mic over in front of you and make sure the little button is slightly tapped so the red light comes on? Or move over near the mic.
There we go.
Thank you. All
right. Tim Day from District Court in the 9th Judicial District in Jackson. We don't have any uniform position from the district courts on this particular issue, and I know this was discussed last time, and I had to leave early, and I think maybe Lily might have offered some of my comments just based on a recent case, and all I can do is mention that as kind of the practical situation that sometimes district judges are faced with in these kinds of situations where you might find, grandparents have raised the child since almost birth. They've been for several years basically the child's parents. The child's parent or parents come back and ask that the guardianship be terminated because it was established because they weren't capable of taking care of the child originally. And so you go through this analysis that we currently have in Wyoming and see if the parent is fit or unfit. And then you move on to whether it's still in the best interest of the child to have the guardianship, whether the original purposes of the guardianship are no longer necessary. And what you can do is find yourself in that situation where maybe you have a marginally fit parent, and based on the original reason for the guardianship, it's probably not there anymore because the parent is marginally fit. But you hear expert testimony from teachers, counselors at school, counselors for the child, who talk about the attachment that they have to the guardian and maybe the special needs that they have, and how it would be seriously detrimental to the child's best interest to just send the child back to mom or the parents. And there's a little bit of a limbo, I think, in the current state of the law as to what power or what we can do in terms of fashioning a transition plan for the child, and how long we can design that transition plan and how many conditions we can put on it. And there have been a couple cases in Wyoming where district courts have attempted to do that, and sometimes it's okay, and sometimes, in one case I can think of in particular, it wasn't, because it wasn't definite enough, and so obviously this bill would kind of address, again, not starting with the fitness of the parent, but what's in the best interest of the child. And of course, wouldn't be prepared to opine on the constitutionality of that, but it does. The current situation does leave us, I think, sometimes in the dilemma of this. Maybe this isn't maybe the best parent, but it's a fit parent, and maybe it's not in the best interest of the child, but do the parental rights trump that? Just a practical example of how sometimes we see this come down in courts and how this kind of legislation might affect that.
Okay. Senator Hicks.
Yeah, Judge Day, you used a terminology that brought in a new concept that the committee hasn't discussed, and that's you used the word marginal fitness. So I'm just curious, is from your perspective, is there a distinction or some way we can delineate between what somebody is marginally fit or the definition of fitness as it applies to the court rulings that we have?
Please.
Well, legally, I suppose you've got to make that decision, are they fit or not? And then practically speaking, we all know that there is a broad spectrum of fitness of a parent. And so the tougher cases are where I think, speaking for myself, you're sitting there and you're going, well, I think I'm going to have to find that this parent is fit, but it's just, they're just over the line. And it may not be in the best interest of the child, especially after I've heard this testimony, but I really don't have any choice. So now I've got to figure out how to transition the child back to the parent's home and do the least amount of damage to the child.
Follow up?
Yes, Senator Hicks.
Mr. Chairman, so taking that to the logical next step, the way the bill's drafted, and we all agree on the concept of marginally fitness. We know what you're describing, and we're trying to thread the needle here. So the way the bill's drafted, it brings in the concept that the determination of the best interest of the child. Does that help you from the judicial side get to this issue of marginally fit? Does that now modify the ability to make a strict ruling on fitness? Because now fitness is modified by the preposition that first we have to look at the best interest in the child. So does this now give you different degrees, whether it's marginally fit, superiorly fitness, or whatever it goes, because we changed that concept now that you have to go through the best interest of the child? Does that help in those determinations? I guess the question is does that help provide the discretionary ability for the judiciary by bringing in the concept of marginally fit when we say it has to be in the best interest of the child?
Please.
Good question. I don't really know the answer to that. I don't know if that would be, if that still raises constitutional concerns that you're not focusing first on fitness as a parent, and as you suggest, you're deciding fitness based on what's in the best interest of the child and how those two fit together. So I'm not sure I could answer that. I think it's certainly, those are factors. A lot of those factors that are set out in this draft bill are the same factors that we look at in determining custody for children, statutory factors that we consider in determining custody of children, looking at the best interests of the child, which is what we need to do.
Okay. Yes, Representative.
Mr. Chairman, thank you. Judge Day, I got a question that currently the way the system works now, and we've heard the horror stories over the past couple of years on some of these instances that have taken place with children, with their grandparents, and the parents coming back wanting to take custody. And I guess my question is, currently the way the law sets now, if they come in and ask for removal of the guardianship, and there's a history of criminal activity, a history of drug abuse, do you take that into consideration now? And with this bill, would this give you more leverage, I guess, is what I'm trying to figure out with the current law and what this bill would do, if it would, because the bottom line is these parents that we're trying to deal with, I think, is the ones that are definitely unfit, the ones that have a lengthy criminal history, have a drug history, and continue down that line. I just want to know if the current law is, if you can address that, or if this bill assists in that.
Judge Day. If at any point any of the other judges would like to come up and support your.
I think the question that I have in looking at this is, does this how does this relate to the standard that we've previously worked under to say, okay, does the reason for that the guardianship was originally established still exist? And if it doesn't, is this a fit parent? Then child goes to parent. All of a sudden this says, okay, balance these best interest factors, but it doesn't talk about how this relates to fitness of a parent and how you assess that. And I didn't see where that explicitly really addresses that. And that goes back to the question that Brian's raised about, would this be a constitutional bill or not?
Senator Nethercott.
Thank you, Judge Day. One piece that I want to draw the committee's attention to, and perhaps Judge Day, is that this bill focuses on the back end of a guardianship when a guardianship is being terminated, not when a guardianship is being established. So is it fair to say that when a guardianship is being established on an involuntary basis and someone is trying to prove that a parent is unfit, can you explain to the committee what factors the court usually considers in making that determination of unfitness like you're currently doing now?
I think, and I'd invite my colleagues to jump in here too, but I think it's basically, it's best interest of the child, that it's important for the welfare of the child. And so you're considering some of those factors.
Mr. Chairman?
Yes, continue.
Judge Day, in establishing a guardianship, is there any statutory requirement that best interest actually be analyzed by the court, or is it solely on fitness or the fitness of the parent?
Judge Day.
See if my colleagues have any. Joe?
And if you could just make sure that mic's turned on too. Thank you.
Mr. Chairman, thank you. To try to answer your question, Senator Nethercott, I hate to do this, but I almost want to go the next step and say, seldom do I actually have contested guardianships. More of the guardianships that I have are consensual guardianships to begin with. And then after the consensual guardianship has occurred and gone on for a while, then the parent or parents will come back and say, okay, I want my child back. But so I understand, and I will now come and try to answer your question the best I can. I actually believe that the standard on the guardianship is not necessarily the best interest at all. I have to make the decision at that point in time, and so frankly, it's very nice. This sounds probably pretty rough, but it's very nice to me when I have a guardianship where it's a contested guardianship and I actually have the evidence that's of a level that I can say you're an unfit parent, the guardianship's in place. Does that answer your question, Senator?
Please.
Mr. Chairman, thank you. I think what we're hearing from the committee is, what are those factors that you're currently considering, that evidence that's brought before you that establishes unfitness at the time a guardianship is brought upon a petition, in those rare circumstances when that occurs?
Okay. Judge Brunel.
Mr. Chair, I'm probably going to miss something, and I'll defer to the attorneys on the committee and my other colleagues that they probably will have some more insight on this. But my initial thoughts to that are they almost literally go to the standard of termination of parental rights. And so is it a situation where this parent is able to provide a safe, secure home, a nurturing environment, and I believe that it may not be exactly the same statutory checklist of a termination of parental rights, but that's where my mind initially goes, Mr. Chair.
Thank you. Further questions of our judges? Yes,
Mr.
Senator
Chairman.
Nethercott.
If I may, in looking at this statutory, in this proposed bill draft, which only deals with the termination of a guardianship and what a court should look at on those circumstances, and if you have a copy of the bill in front of you, that might be helpful.
I do.
On page 2, lines 1 through 5.
Just a moment. Let me get it open. Page 2, lines 1 through 5.
Yes. Specifically on line 2, after the comma, it says the court shall consider the best interests of the child. But it doesn't say that the court shall not consider fitness.
Exactly.
The fitness of the parent is still to be analyzed upon the termination of a guardianship, correct?
It would be my position that I must make that finding, yes.
So upon the termination of a guardianship, it's your opinion, based on reading this bill draft, that you would have to make a finding of fitness of a parent, correct?
Yes, ma'am.
And you would also have to consider the best interest of a child, correct?
Yes, ma'am.
Thank you.
Okay. Committee, anything else from the judiciary at this? Oh, Senator Hicks.
Mr. Chairman, a follow-up. So I think my colleague has hit the crux of the issue for me, but under that scenario, we've gone through a fitness determination. And we bring in this concept of maybe marginally fit, but still meets the legal definition. Under that scenario, and you're sitting there and you've gone through the fitness test and there's a determination made, but you've also have to look at the best interest in the child, and they're mutually exclusive. You guys deal with this situation where you may have a parent that meets the definition of fitness, but certainly may not be in the best interest in the child. So under that scenario, how do you make a determination of which one of those factors is most important in weighing the decision? Then do you go through the rest of the bill draft and those things that are laid out? Because that's the real world and the dilemma. The needle that we're trying to thread is that very issue. Is that scenario where we have a case where there may be a determination of fitness that may not be in the best interest in the child. And that's the testimony that we've taken for the last 2 years. And that's what this committee is fundamentally trying to grapple with, is how do we thread that needle? And so do these other circumstances or scenarios that we lay out in the bill then help you make that decision, bar the constitutionality issue? We'll cross that bridge when we get to it. But with the other factors that we bring in now, does that now allow you to make a determination that if we get into these scenarios where we have a marginally fit parent but meets the legal definition, but it may not obviously be in the best interest in the child, that you can rule in the best interest of the child? Because if this doesn't get us there, and we've been spending a lot of time on a bill that is not what the intent of this committee is trying to grapple with. So I'd be interested under that scenario that my colleague laid out, how that plays out in your mind.
Mr. Chairman.
Senator Nethercott.
Thank you. Just to follow up on Senator Hicks. On his concerns, when you find a marginally fit parent, what tools are in the court's toolbox to handle that situation where you're not interfering with that parent, the marginally fit parent's constitutional rights, and how you're interweaving the balancing test of the best interest standard? And it's my belief, and I'm curious to hear your thoughts on this, that the tools provided in this bill that allows a transition plan back to that marginally fit parent allows the court some resources available to, upon a finding of a marginally fit parent, to transition that child back to the parent in a way that may address some of those concerns associated with the marginalness of the fitness, such as drug abuse, and maybe requiring drug testing associated with that transition plan to the fit parent. Is that a reasonable tool that this bill provides?
Judges.
That would be, my opinion would be that it would be very helpful for that. You know, to Senator Hicks's question as to whether if you found a marginally fit parent, but that under the best interest, you found that it wasn't in the best interest of the child, whether that could somehow trump fitness analysis would be a question probably to be answered by the Supreme Court on the first appeal of that kind of case. But
If I may, Mr. Chairman.
Please, Judge Brunel.
I concur with Judge Day, and again, this is just my personal opinion, is that, and Representative Pownell actually asked a question, does this give additional tools to what I currently have? And I would respond with the answer, yes, it does. And I think that Judge Day summarizes it very well, where I look at this and I see, and the tool that I would use this for is a balancing test to say, okay, now what can I do and how's that going to work? And hopefully I would be able to have a record that would have adequate findings or adequate evidence, and then I could bolster that with my findings so that it would actually balance that and not unnecessarily invade the constitutional rights of a parent. I think that all of you, and I apologize, you probably have had this discussion and I've not participated in it. And so if I'm bringing up something, Senator, that I shouldn't, you know, probably the termination, the petitions to terminate guardianship that I see more than others are exactly what I think Senator Nethercott refers to, and that's somebody who's become involved in drugs. They say, okay, they've cleaned up. I'm now sober. I don't have those problems. I've got a home. I've got a job. And then you have some tools with this that I think may be valuable. So if I've gone too far, Mr. Chair, please accept my apologies.
Representative Winters.
Thank you, Mr. Chairman. And Judge, I sure appreciate your being here. Some of the questions we've had over the last year regarding this bill, because, and to give a little background for myself, having adopted 3 children and being through the process that this is involved with multiple times, my heart was knit to the bill initially, but I do have a number of questions regarding it. And I would love to get your take on, so on page number 2, lines 7 and 8, the relative competency and fitness of the parent. When you talk about that relevancy, we actually are creating something that is subjective. And that's kind of the question that we've heard several times on page number 3, the quality of the relationship on lines 4 and 5. Again, a question of subjectivity. And then Then on page number 4, lines 7 and 8, any other factor the court deems necessary and relevant. So what we come away with feeling in this bill is that it's expanded quite a lot to where the bill opens it up too far. And that in considering the factors that I've just brought out about the bill, do you feel like it opens it up too much, the current statute too much? It makes it a lot more subjective? Or how would you interpret the statute if this were involved in your ongoing decisions or your future decisions?
Judge Blumel?
Mr. Chair, in some respects, it's nice to be able to step back as a district judge and say, well, that's a wonderful argument, counsel, but the law doesn't allow me to consider that, and just be able to address it very simply and succinctly. But I think when you deal with particularly the best interests of children, and you deal with this moving target that I think we have with children, and the broad range of factors that we can have in families, I personally don't find that this would be unreasonable and that it's too far or gives too many opportunities or options. But that's not really for my input. That really is yours as the legislature. If you choose to give those tools to the judiciary, then it's something that is discretionary, where we can say, yes, I find that to be worthwhile, or no, I don't. And when I make those decisions, I have to be mindful that I better have a reason for doing it so that it's supported from there. Mr. Chair, thank you.
Mr. Chairman.
I don't know if that responds adequately to your question, sir.
Senator Anselmi?
So, Judge, what I'm hearing you say is there's no pH or litmus test that we can just dip this child in and come out with the absolute answer?
Yes, ma'am. If I may, Mr. Chair, yes.
Other questions for our judges? Thank you very much. Appreciate you.
Thank you.
Being here. And when we get back into committee discussion, there may be some additional questions or clarifications sought. Thank you. All right. State agencies, county agencies. Anyone would like to weigh in on this? Prosecutors, AG, Department of Health, EFS. Trying to remember all these names. No. All right. With that, folks, we're going to go to public comment. And if you could keep your comments short and to the point so that we have time for everyone to speak to it and address the bill. Let's talk about the bill in front of us. So with that public comment, please come up and announce yourself. If you're affiliated with an organization, let us know who that is. Thank you. Hold on for a second, Donna.
Mr. Chairman, members of the committee, I'm Donna Sheen, and I am the director of the Wyoming Children's Law Center. And I come and want to speak in favor of the bill. I guess generally what I would say is that our guardianship laws do need a lot of work. And this is a particularly important part of our guardianship laws that has been left undefined for far too long. And I would support everything that the judges testified to. One of the things, though, that I would say is I believe we need to stop using best interest of the child so much as to talk about balancing children's rights, because there are certainly situations where a fit parent, putting a child back with that fit parent is absolutely definitively going to cause harm to the child. children have rights too, and we have to recognize that. And currently, our guardianship law doesn't address that. So this is an important way that we can add back in the ability of courts to balance that and ensure that children are not placed back in a situation that could be emotionally harmful, that would end an important relationship, that would put them back in fear when they've just recovered from perhaps some devastating, post-traumatic stress, or they're still struggling with that. And so we really need to put this protection into the law, and I would urge your support, and I would stand for any questions.
Questions from Machine? Thank you.
Thank you.
Ma'am?
Mr. Chairman, thank you. My name is Lindsay Sears, and I am the president of Homeschoolers of Wyoming. And I would like to stress the importance of not passing a bill which allows the court to determine the best interest of a child without first finding the parent unfit. A case just decided in the Georgia Appeals Court illustrates my argument. The Georgia Court of Appeals issued the decision last month reversing the trial court's decision in Borgers versus Borgers. The trial court stated the following about homeschooling. The court finds it to be a shame that the defendant mother has not taught her children to be independent. The court finds the child's enrollment and attendance at the Montessori school should be convenient. The appeals court reversed, and Chief Judge Dillard wrote a special concurrence which states in part, the liberty interest of parents to direct the upbringing, education, and care of their children is the most ancient of the fundamental rights we hold as a people and is deeply embedded in our law. This cherished right derives from the natural order, pre-exists government, and may not be interfered with by the state except in the most compelling of circumstances. I write separately to express my serious concerns with the court's decision to summarily substitute its judgment regarding the child's education for the mother's without identifying evidence of the compelling circumstances necessary to interfere with her constitutional parental rights. While the trial court may be right that it would be more convenient for the child to attend the Montessori school, a parent's constitutional right to make educational choices for his or her child is not limited to those a judge or any other state actor deems to be convenient or wise. And when the state actors engage in this sort of Orwellian policymaking disguised as judging, it is any wonder that so many citizens may feel as if the government does not speak for them or respect the private realm of family life. In sum, I take this opportunity yet again to remind our trial courts that in making any decision or taking any action that interferes with a parent-child relationship, our state statutes are subordinate to and must be construed in light of the fundamental rights recognized by the federal and Georgia constitutions. So this guardianship bill would wrongly allow for a court to decide it thinks a guardian is a better choice based on the educational needs. If you see in the bill, page 3, line 9, the bill says the ability of the parent and the guardian to meet the child's physical, emotional, developmental, educational, and special needs. Thank you.
Thank you. Any questions from Ms. Sears?
Mr. Chairman.
Yes, Senator Nethercutt.
Thank you, Mr. Chairman. Ms. Sears, is that correct? Do you disagree that some parents' rights should be terminated?
In specific cases,
they should be terminated?
I agree.
And do you believe in some cases that involuntary guardianships are appropriate when a parent is on drugs or harming their child through child abuse?
I agree.
And what do you think those standards should be?
Ms. Sears?
The standards for
a court to consider when deciding to take away a child from an abusive situation?
Well, there are many standards that need to be considered. Obviously, if they're breaking the law, I believe that is a factor to consider.
And do you believe that this bill says otherwise?
I just believe that this bill does not put first the parents' rights.
If I told you that the bill required a fitness determination of the parents, would you feel better about the bill?
Yes.
So if it was true and you heard from the testimony from the judges that that requirement is still within this bill, do you feel better about it?
I'm not sure.
If I told you that was the intent of this bill, do you feel better about it?
Let's direct the comments back and forth through the chair in both ways, please.
I would have to make a further reading.
And just one more comment, Mr.
Yes.
Chairman.
Follow up.
The statement that you read was the writings of a judge, correct?
Yes.
From the judiciary.
Yes. It was also reversed from another trial court.
Okay. Yes, Representative Winters.
Thank you, Mr. Chairman. And to keep from turning this into some sort of legal battle, as though it's a courtroom, I do want to just ask a question, though, of you. Is it just your concerns with the bill would be that you're afraid of what this may potentially do in the future, unintended consequences, regardless of intention? The intentions of the bill are to address a certain issue, but are your concerns that they may be misused, say, a couple decades from now, to where it may infringe upon the rights of a parent in a different circumstance? Is that your fear?
Mr. Chairman, yes, that is my fear. Exactly.
Right. So, Mr. Chairman, thank you. So your questions are not necessarily regarding the intention of the bill. It's on its potential misuse at some future date.
Yes.
Thank you.
All right. Any other questions of this witness? Yes, Representative Jennings.
Mr. Chairman, Ms. Sears, thanks for being here this morning. I just want to play a little bit on Representative Winters there. If you have the bill in front of you?
I do not.
Oh, I'm sorry. So throughout the bill, I think, if I'm understanding you correctly, your concern is things like the vagueness of close and, on page 2, close and substantial relationship, who gets to determine that. Page 3, a parent-child type of relationship, who gets to determine that. The quality of the relationship, who gets to determine that. You're seeing a shift to the government or to the state to making a determination on these vague factors, or even to the court, based upon the state's assessment of those. And that seems to be adequate care on line 12, or how the child interacts or communicates. So if a child didn't speak for a while, then the expert could come in and say the parent is not being very fit here, or there's an issue, or it's not being adequate. Am I understanding you correctly that you see the vagueness and who determines those things as being very serious for parental rights? Thank you, Mr. Chair.
Yes, Mr. I would agree. I do not think that there is enough language in the bill to determine the unfitness of a parent.
All right. Any other questions? Thank you, Ms. Sears. Other input? Public comment? Sir.
Chairman, my name is Douglas Petersma. I'm a father and an education specialist.
Sorry, your last name?
Petersma.
Okay.
I'm a father and an education specialist. I direct a homeschool auxiliary here in Cheyenne, Wyoming. And I would like to speak to the importance of protecting a child's liberty right to be raised by a parent unless the parent is determined unfit. The bond between parents and children is one of the most powerful of human relationships. Policies affecting these relationships have profound ramifications for our society. The role of a parent in a child's life is an irreplaceable one. Dr. Jack Shankoff, board-certified pediatrician of the Harvard Graduate School of Education, says, even when young children spend most of their waking hours in childcare, the parents remain the most influential adults in their lives. Dr. Shankoff also said the hallmark of the parental relationship is the readily observable fact that this special adult is not interchangeable with other adults. In a 2004 Nebraska Supreme Court case regarding guardianship, the court said a biological or adoptive parent's superior right to custody of the parent's child is an acknowledgement that the parents and their children have a recognized unique and legal interest in and constitutionally protected right to companionship and care as a consequence of the parent-child relationship, a relationship that, in the absence of parental unfitness or compelling state interest, is entitled to protection from intrusion into that relationship. Hence, the parental superior right to child custody protects not only the parent's right to the companionship, care, custody, and management of his or her child, but also protects the child's reciprocal right to be raised and nurtured by a biological or adoptive parent. Establishment and continuance of the parent-child relationship is the most fundamental right a child possesses, to be equated in importance with the personal liberty and the most basic constitutional rights. The bill draft as it is being considered in section 1, subsection B, page 4, lines 10 through 13, states that the court may consider the factors in subsection A of this section without first making a finding of parental fitness or a finding that the guardianship is no longer necessary. Mr. Chairman, I ask you not to move this bill forward unless and until a change is made to include that the court must find the parent unfit before determining the best interest in guardianship change when the parent objects. Thank you, Mr. Chairman.
Thank you. Any questions for Mr. Petersma? Thank you, sir. Public comment. Ma'am?
Chairman, I'm Jan Loftus. I'm a volunteer coordinator for parentalrights.org in Wyoming. And I provided you with a yellow folder with a couple handouts today. I want to mention the bill passed last year and the historic tradition of parental rights, that they are one of our fundamental rights. And last year it was put into statute that the state cannot interfere without a compelling interest. This is the highest level of protection if we think about our other fundamental rights, that the state needs a compelling interest to interfere with this familial relationship. The U.S. Supreme Court calls them liberty interests and family privacy interests. In the one handout I provided, it's a parental rights tradition in U.S. Supreme Court excerpts. I highlighted two. Quillian case where it says unfitness must be decided before best interests. The Santosky case, fundamental rights do not evaporate because the parents have lost temporary custody or have not been model parents. I would like to suggest that if the bill was to move forward, that the idea of fitness not be implied, but be stated, as it's currently been said on the committee today that it's implied, but it should be actually put into the statute. The burden of proof, if the parent wants to stop the guardianship, if the parent was adjudicated unfit in the past, the burden of proof should be on the state, not the parent to prove fitness, but the state to prove unfitness. Why do I say that? Well, how would we prove ourselves fit as parents? If you think about your own situation, how are you going to prove it? And now imagine that you're young and you're poor. How are you going to prove that you're fit? Does it set up an impossible situation so that this bill would turn out to be a termination bill instead of what it's intended for? I also want to speak to the relative competency, and that doesn't consider the special, unique relationship that parents and their children have. That is a different relationship than children have with other people. On the case, the Wyoming Supreme Court case SRB 2009 that I also provided for you, I highlighted a few things, but the orange highlight: in guardianship termination proceedings, as in appointments, the biological parent is entitled to custody of his or her child, absent of finding she is unfit. One last thing, there's good policy rationale for encouraging parents to agree to temporary emergency appointment of a guardian. Parents will be reluctant to do so if they learn that later they're going to have to demonstrate fitness in order to terminate the guardianship. On that same SRB case that I provided in pink highlight, the court said that it would unnecessarily place children in jeopardy if the parents are reluctant to put their kids in guardianship when they ought to. Representative Stith asked me about lengthy guardianships, and that's also discussed in the same case, highlighted in yellow. And I would propose that the committee consider some date or maybe individually a brief bill that addresses just this point. And it's, I think, a very good write-up the court made in this case about the concerns over very lengthy guardianships. Thank you.
Thank you, Ms. Loftus. Questions? Witness? Thank you. Is there any other public comment?
Chairman, members of the committee, my name is Cassie Craven, and I am with the Wyoming Liberty Group.
With which group?
The Wyoming Liberty Group.
Okay.
Mr. Chairman, members of the committee, this guardianship bill and its intentions are very admirable. I commend these fine people who have been raising these children when the parents are nowhere to be found. However, I believe that the bill in its current and existing form will only increase litigation. It will put people at an economic disadvantage at significant risk of losing a fundamental right. And I don't believe that it would be in the best interest of the children to have a long drawn-out guardianship and uncertainty. Moreover, disparate results will result from this bill. Different judges in different jurisdictions will interpret these factors differently. There will not be consistent precedent to rely on, and each and every case may end differently depending upon the judge that you have to see. This bill will ensure work for private practice attorneys, no doubt. There will be litigation and there will be appeals to the Supreme Court. This bill will also put undue burden and additional cost on the state. When you're talking about taking a fundamental right, I believe that court-appointed counsel is necessary, court-appointed guardian ad litems are necessary, and I don't know if that's a consideration that's been fully thought through. Parental rights are fundamental and protected, but I believe that I have a better alternative for this committee to at least consider and perhaps begin researching. 14-2-310 allows for persons authorized to bring termination petitions and qualify standing. Why should a child be hung out in limbo for possibly years? Does a parent get to decide when it's appropriate to parent their child and when it's not? And do they get to come back years later? The solution to this problem is to create standing in a different way, not to slowly chip away at fundamental parental rights and try to shoehorn it in where it doesn't belong. I don't know what the ideal solution would be, what the appropriate time limit is for a termination petition to be brought. But I think that somebody who's raising a child when a parent has abandoned them or abused them ought to be able to have their parental rights at risk. But those rights should be terminated, not slowly chipped away at. To do so would only derogate what is established clearly by the Constitution. And we need to pick a side here.
Okay.
I have a few issues that I'd like to address. The guardians as protectors propose that the burden of proof in these guardianship proceedings should be on the parent. And I believe that's not in accord with the Constitution. There is no guardianship right. There is a parental right. And so that's the sticking point. Additionally, in their memo, they cite the statutory authority that allows for the state to intervene, but unfortunately in these circumstances, guardians don't have rights and they're not wearing the white hat of the state. And I would ask this committee to consider why, if the abuse and abandonment was so severe, why DFS hadn't already intervened. I think that the appropriate response would be to consider that standing in a termination proceeding. Up the ante and let the judges decide, is there enough evidence here that this person's parental rights should be taken away? Because if these cases are so severe and if the facts dictate that, then I believe that there might be a way to craft that solution.
In the Truth About Troxel memo proffered by the Guardians as protectors, the group states in part, the Troxel case lacks applicability for the Wyoming children, currently in involuntary guardianship proceedings. They pick apart at the facts and how it's different. But I pose to this committee for serious consideration, does the Troxel case lack applicability for the Wyoming biological parents who have a fundamental and constitutional right? And in closing, I would like to address a few of the comments that I've heard already. Senator Kinski, I believe, yes, addressed the presumption concerns, and I share those deep concerns, and the balancing of the factors that makes this a horse race. Again, the results will be different in every single jurisdiction with every judge that you see. And maybe they're not the best parent, but they are still the parent. And I agree with that. And I'd like to reiterate that, because until that fundamental principle changes, we're chipping away at a right. Even LSO conceded this morning that the disparate impact of Troxel across the states has been noted. And it is of note that 28 states have adopted a bill similar to this, but not to the extent to the bill that you see today. And some have been litigated, and some have been overturned, or some have been recrafted to come into accord with the Constitution. Even Judge Day couldn't answer what constitutional implications that this bill might have, and it's been alluded to that it will end up at the Supreme Court. So to covet Senator Hicks's concerns, how do we thread this needle? And I think that we can come up with a cleaner remedy that would be better for the children, better for the parents. Because again, parents shouldn't get to decide the time schedule by which they parent their children. And there should be a time and there should be a place where they can lose those fundamental rights. But chipping away slowly in an uneasy way that's very unpredictable and tenuous in the court system is not the way to do that, in my opinion. And I'd stand for any questions.
Thank you, Ms. Craven. Questions, this witness? Yes, Representative Winters.
Thank you, Mr. Chairman. So based on the things you just said, I guess the question that comes to us, and then the question regarding the bill is this. Should a parent have to fight for termination of guardianship to the same extent that someone would have to fight for termination of parental rights? We heard from one of our judges that currently it's almost at the same level now. And so with that in mind, does this bill actually make it less or more difficult to terminate guardianship? And does it place more burden on the parent, or does it lessen that burden?
Craven.
Mr. Chairman, Representative Winters, I believe that the bill in its existing form closely parallels a termination proceeding, but the way that it's being done, we don't know how it's going to end up, how long it's going to take, and it puts an undue financial burden, I think, on the parent. I think based on the testimony we've heard at length regarding some of these fine people, we're going to be looking at parents of the children who can't afford attorneys and can't afford a lengthy battle. And I just wonder what would happen in those circumstances. Whereas a termination proceeding on the proper timeline, and I'm not sure what that would be, I'd be happy to work with the committee toward that, would allow for fundamental due process protections. Whereas I don't believe that this does that. And moreover, I'm very concerned that it attempts to shoehorn in the modification of custody standard, which is you can bring it every 6 months on a change of circumstance. And I would just encourage the members of the committee to remember this is not a custody battle. This is a parent and a guardian. The rights are different.
Okay. Any other questions? Yes, Representative Jennings.
Mr. Chairman,
Cravens.
So do you feel like that this could be perhaps approached easier through amending current statute, or something that would be a little less vague and a little more? And then secondly, I noticed that there's not in the memo a fiscal, that there will be court appointed lawyers brought into this. Is that something that that you or maybe some other lawyer can address a little bit of that? What are we looking at?
So do you have a question for Ms. Craven, or should we go to, are you talking to LSO?
I'm sorry, Mr. Chairman. The question was did she feel like that there was a way to address this in current statute, to perhaps amend current statute that would be easier and more concise?
Okay. Ms. Craven?
Mr. Chairman, Representative Jennings, I propose 2 changes. First, I propose amending 14-2-310 to consider standing for these people. on a timeline that would be in accord with the Constitution, and that might require some research. Secondly, based on the testimony we heard from Judge Day this morning, I now think it would not be a bad idea to consider in the current bill something that allows for a graduated schedule and return in guardianships. I don't see how that would be an implication on constitutional rights so long as it's done under an appropriate timeline.
Okay.
And to answer the final question, I apologize, Mr. Chairman. On the fiscal note, I do think that that is a concern that has been not discussed, at least in the meetings that I've attended. How are all these court-appointed attorneys going to be paid, and what kind of influx are we going to see in those numbers?
Okay, Senator Nethercott.
Mr. Chairman, thank you. I want to remind the committee what we're dealing with here are private actions with family members, typically for private guardianships. I think it's easy to confuse some of these concepts and scenarios that take place when the state comes in and takes a child, as Ms. Craven has referred to, in a termination proceeding because of abuse. And in those circumstances, when a parent's rights are being terminated, there are due process rights that attach because of those constitutionally protected interests. And in those circumstances, the court does appoint attorneys for those parents to represent them in those actions. In this particular case, in this particular bill, we're dealing with private party actions. And again, I want to remind the committee that the timing of the action that we're talking about in this bill is at the end of a guardianship, when a parent on their own initiative moves the court to terminate a guardianship. And the court is still required to determine whether or not the parent is fit under this bill. But what this bill does differently, and we've heard provides an additional tool to the judges and to the families, is requires the court to actually look at who this bill is putting first, and that's children. And says, you know what, this parent may be fit. We're going to also look at what the best interest of this child is in light of the fact that the parent has been absent for a period of years. And so we're going to walk this through very carefully and understand what works best for this child and what works best for this family in light of the unique circumstances that each family faces and that each challenge faces. I suggest to you that I'm very concerned about the particular testimony we've heard, which really is speaking out of both sides of the mouth here, of this preservation of parental rights and, yes, this push to terminate. And so it seems to me that the body is being asked to ignore the value of this bill for guardianship and instead focus on a faster, more quicker approach to actually terminate rights. Ms. Craven referred to Title 14, and the timeline for terminating rights by the state for a parent is 15 months. 15 months and you could terminate somebody's rights. My understanding of what the committee's wish is that would not be appropriate, particularly in light of the legislature's previous activity of passing the parental rights bill. And instead, this guardianship bill acknowledges that families are complicated, as well as drug addiction and abuse and mental health issues, and that those are not finite circumstances and that those are fluid, as is the human condition. And this guardianship provides additional tools to courts in this very rare circumstances where this is happening to ensure that both parents' rights are met, as well as the interests of children. That's what this is about.
Is there a question in there for Ms. Craven, or is more a response to her comments?
Mr. Chairman, I was responding to the question of Representative Jennings, who was asking about court-appointed counsel,
All right.
understanding the distinction between state action and this private litigation.
Yep. Thank you. Representative Winters.
Thank you, Mr. Chairman. And so I suppose this could be for either Ms. Craven or Senator Nethercott, but so I know that right now,
if we're going to get, is it going to be more of committee discussion? Because
No.
we may be able to clarify some of this with some LSO.
But I'm actually, Mr. Chairman, I'll explain what I'm doing. I just need some clarification regarding how this would actually work in current legislation. So I know that right now, if 15 out of the previous 22 months, the child has not resided with their parent, then you can potentially call for that child to be placed in a different circumstance, a more permanent circumstance. So would this bill then be contemplated sometime before that 15 of 22 months or after? When does this bill actually take place in relationship to when the parent would petition to have the guardianship terminated so that they can actually take custody of their child again. Where on the timeline would this bill most likely fall into place? I'm not sure who to address the question to. I'm just trying to see the sequence of events in a court proceeding.
Perhaps we could come back to LSO and if you'd like to weigh in on that particular question as the crafters.
And Mr. Chairman, it may actually be best directed toward our judicial branch as well. But I guess I'm trying to see that particular picture there. There is value in the bill. I understand in certain circumstances. I'm just questioning how broad we are and what we're doing on the timeline.
Tell you what, we're kind of getting into a lot of discussion back and forth that maybe we can work on. And is there any other particular questions to be directed to Ms. Craven? Yes, Senator Kinski.
I just want to make sure that I'm understanding clearly what I think you said. So let me repeat back in my own words. In the typical situation that we heard the judiciary describe so far at every meeting that we've considered this, there's not a nice, neat little timeline. It's usually mom is gone, dad's unknown, grandma and grandpa have had the kid for 2 years. Mom finally shows up and thinks she's cured. So there may have been a determination of unfitness at the outset, or it may be that they're just now getting to court because they're afraid of giving the kid back to mom. So maybe we've got essentially sort of a retroactive finding of unfitness, and the judge is left with this sloppy situation. I heard you say in a situation where there's some question about the parent's fitness, you think constitutionally it's permissible to explicitly give the judge some tools to assess whether, not to just say on a binary determination, okay, you're fit, here's your kid, to say, we're going to put some parameters here. We're going to kind of ease the child back into the situation. We're going to see if mom really is fit and see if she really is stable. And we're going to try and protect the kid from an abrupt ripping away from these grandparents. You feel like that would pass constitutional muster, whether initially there's some question about the fitness of the parent?
Ms. Craven.
Mr. Chairman, Senator Kinski, I'm in support of a tiered return schedule upon a finding that a parent is fit, so long as the time is reasonable and due process is afforded. I think that would be perfectly appropriate. And from the testimony I heard from the judges this morning, something that is needed. But as far as these presumptions and the burden of proof, it goes too far.
Thank you, Mr. Chairman.
Representative Winters.
So thank you, Mr. Chairman. This would be a follow-up to that question for you. So based on your testimony before, you mentioned 14-2-310, which is the termination of the parent-child relationship. So then based on this exchange that we just had, do you think that a graduated schedule would be best placed under 3-3-1107, which would be created actually at this point? Or do you think it belongs under 14-2-310? I don't see it belonging there. So would there potentially need to be something enacted similar to this that would create a graduated schedule, in your opinion?
Ms. Craven.
Mr. Chairman, Representative Winters, yes, it would not belong in 14-2-310. 14-2-310 would only dictate when a parent could be terminated. The appropriate place for a graduated schedule would be in the guardianship section of the statutes. And I also wanted to address, if I could, that while these might be private party actions, the Troxel case and its progeny very clearly state that when a third party, that's the phrase, third party, is attempting to intervene in a parental right, that triggers due process. So it doesn't matter that it's a private party. And I believe that it's talking out both sides of the mouth to encourage the primary concern of best interests of the child and the child's rights. Show me in the Constitution where the child's rights are. There's a reason they have guardian ad litem. They're minor children. And while their best interests must be noted and considered, there's a constitutional right to being a parent, and I can show you where that exists.
Okay. All right. Yes, Representative Olson.
Thank you, Mr. Chairman. Ms. Craven, you're a lawyer for Liberty Group, is that correct?
I'm an attorney in private practice, but I do hold a contract with the Wyoming Liberty Group, yes.
I may be too simple-minded of a lawyer. When I read this bill, and I have heard testimony today from you and others. The testimony from you is that the legislation as crafted doesn't require a finding of parental unfitness, though I heard the reverse testimony today as well. As I read page 4, lines 10 through 13 of this bill, what I read is that the bill allows for judicial discretion to bypass parental fitness and simply rest on a best interest of the child analysis when determining whether the guardianship should continue or not. Is that your reading of the bill when you speak about the lack of parental rights inside of this bill?
You have a copy of the bill?
I do. Mr. Chairman.
Thank you.
Representative Olson, it's my position, not on what the bill says, but it is my position that there must be a required finding of fitness of the parent, or this will not pass constitutional muster. It's been stated that it's implied in the bill, but I agree with Ms. Loftus. It must be stated explicitly, or you face, I think, pretty severe consequences that it will be overturned by the Supreme Court. We can't infer a constitutional right. It needs to be stated explicitly and be clear. I don't believe that it would be constitutional for a judge to bypass that and only consider best interest of the child. I would, I guess, argue that a balancing test might be put into place in terms of, how much we weigh the best interest of the child. But I don't believe there's any question in any case law that the Supreme Court has found that the fundamental parental right has to reign supreme.
Follow up, Mr. Chairman.
Yes,
So, Ms. Craven, let's just look at the language of the bill. On page 4, line 10, it begins, the court may consider the factors in subsection A of this section without first making a finding of parental fitness or a finding that the guardianship is no longer necessary. What does that mean?
Mr. Chairman, Representative Olson, you'll see I have that exact provision highlighted on the copy I'm looking in front of me because I don't know what that means. I think what it means is that the bill as it exists today is unconstitutional.
Any other questions? Ms. Craven. Thank you very much.
Thank you, Mr. Chairman. Thank you, committee.
Okay. All right. Is there any last public comment? Ma'am? Come on up and speak in the microphone. Since this is being broadcasted, please, even though you've introduced yourself before.
Oh, sure. Okay. I'm Annie McLaughlin, associated with Wyoming Guardians as Protectors, grandmother. And so I've heard a lot of, I won't take too long. I do agree with, obviously I'm favoring the bill. We passed out just as humbly submitted amendment suggestions that might strengthen the bill. Because I know that, the homeschoolers, and of course, my daughter is evangelical. She homeschooled her kids for 3 years. I get it. She's a great parent. We're not talking about homeschooling. And we don't want to have a bill that the people have to testify against because they're afraid that there's unintended consequences, obviously. So I remember one time, Chairman, where I believe it was Senator Kinski says that maybe we need to tailorize this bill very narrowly to make sure that it doesn't exclude or that it doesn't, bring on those unintended consequences. I mean, obviously this bill to me is not about homeschooling. And if you would, let me get my phone. Do I have permit? Can I get my phone? I wrote something on it that I wanted to say to you.
Certainly.
But I think it's a great bill. I do think that, obviously none of us, I believe in the Constitution and the parents have a presumptive right to control the care of custody. Of course, no one in this room doesn't believe that. But we also know that, and I'm not going to argue case law, I'm not a lawyer, but I read, and of course there's just as many cases, if not more, that say very differently that if the presumptive right prevails unless there's a compelling state interest to show that there's harm or detriment to the child. This is certainly a case where we've got harm and detriment to these children. And I like the law because it doesn't terminate rights. Now, you all know that my grandson's father was just sentenced again, who was actually going to go back by the judge to him. And then he got caught with meth and a gun and counterfeiting, and now he's sentenced to 10 years in prison. It's a sad thing for my grandson. I have a daughter who I love. I've tried to help. And my story is, I'm saying the story not because to focus on me, but my story is common. I was in health, Chairman, I was in health reach yesterday because my grandson had an ear infection. He had a fever. So I went over there on Del Range. I was there for a long time, and I struck up a conversation with a woman. She goes, "Oh, how long have you been waiting?" "Oh, my grandson's sick." "Well, my grandson's in there." And I relayed this to Chairman Kirkbride last night. And she said, for a physical, "I'm raising mine," she said. "Oh, really?" I said, "Well, I'm raising mine." "How many?" "3. "How many for you?" "3. I said, "Can I ask you, under what circumstances are you raising your grandchildren?" And she said, "My daughter's on meth, and there's different fathers for different children." And I said, "Well, then you have guardianship. Did you know about our organization?" I handed her a card. She actually teared up. She said, "I thought I was the only one." This is everywhere. I just got a call a couple months ago from a family in Star Valley with 3 kids. The grandpa just died of cancer. The mom's on meth. And I met this woman because my daughter practices medicine at Mayo, and her colleague's sister is the woman on meth. So she asked, "Can I have her call you?" And she doesn't have any money to raise the children. She wants to get power, but mom says that kicks in child support payments, so she can't. So this bill really, I like the bill too because I don't want to have to terminate my daughter's rights. DFS did that in 2005, and it damaged her. And I've had her in my house when she shows up homeless. I like this bill because it takes away the threat of a parent can just waltz into court and say, "I'm fit because I'm going to use that power money and that housing to get the drugs." And that's what they do. I don't know if any of you are familiar with really the drug culture, but I am. I volunteered at Comey. I see the people. And this bill, let's fix it. Let's fix that narrow language in to exclude homeschooling or the parents who give Cheetos over apples. That's not what this is about. And to respond to some of the other comments, when we go to court, the parents show up pro se. I mean, was that the right word? They come in, they don't have an attorney. They get what they just come in, "I'm fit." We pay $300 an hour attorneys, and they tell us they're going back because we don't have standards in place that fine-tune what constitutes unfitness. And why in the world shouldn't the parent, if we look at those amendments, it talks about the compelling state interest to secure a child's right to a stable home environment and to preserve the existing loving child-parent relationships. I would love it if I had a daughter who could say, "Mom, I'm gonna clean up," but she's been on drugs for 28 years. And I don't want to terminate her rights because I don't want to hurt her. This allows me to protect the child and know that she can't just waltz in without saying, "Okay, Judge, I know I've been on drugs because you found me unfit in 2013, but this is where I went to treatment. And this is where I did this." And I would open arms to her. I would buy her a house. I would put her on my rent. We don't want to terminate our own child's rights. This is a beautiful law because it needs to be fine-tuned because we don't need people to come up from the homeschooling thinking that a judge is going to find them unfit because they're homeschooling. So let's look at those issues. And in terms of altering the standard of fitness, if I could just say, they should have to prove that they are fit. If they're found unfit for abandonment and neglect and ongoing drug use and perpetration of domestic violence, whatever this is, and combination thereof, in my situation, my grandson turned 6. They've been gone 4.5 years. That's a long time in a child's life. So, and I'm just one of many stories. So this is about if there's a problem with the fitness thing, there is, I took it upon myself to read LSO's memo last October, which was great. And the Wyoming case law regarding unfitness factors of biological parent. This is by the 12 factors that the Wyoming Supreme Court found that will in sufficient combination support a conclusion that the child is unfit. 12 factors. So that would be great to incorporate that in the law. And one of the biggest ones is the child has a history of parents surrounding himself or herself with child with unsafe individuals. And then, of course, the big one is on criminal behavior as particularly as it relates to ongoing drug use and addiction. We live in a culture of drugs, and it's hit Utah, it's hit Maryland, it's hit Wyoming. And we know that there's 11,000 kids, and that's just the kids on the radar, not the ones we don't know about. I have a letter from Debbie Walter, who wanted to be here today. A lot of people wanted to be here today, but grandparents have to work to support their kids. So, but Debbie Walter she takes in all the guardianship cases, around here. And
do you have copies of the letter we could circulate rather than read?
Oh, I won't read, but I'll give you a copy. I'm sorry. Basically, she just says that over 90% of the kids that are the guardianships that come in are because of debilitating drugs and abandonment and abuse and traumatic. Kids are exposed to traumatic episodes far before they ever get guardianship. And so we're not talking about homeschooling. Let's get this narrowed to where people say, okay, because a presumptive right only applies when a child is not in danger. And that protection of harm and danger, and like Donna Sheen said, they have rights. And it has, and I'm not going to go and quote laws because we have it all over our website. We're smart people. We contact law professors, we contact attorneys at UW, and we say, show me laws that we can put on our website. So this is in a matter of who says who or what laws. We all love parent rights. I'd be really upset if somebody said I wasn't a fit parent because I don't feed them right or because I decide to homeschool. So please, let's get this bill right, and let's don't make it something that it's not. This is a serious problem, and it needs a serious fix. And I'm not making this up. It's statewide, and we have to get your vote to fix this. So task force, I don't know. That's all I have to say. I appreciate your time.
Do you have any questions of this witness? Questions? Thank you.
Thank you very much.
All right. Is there any other public comment? All right. We're going to close public comment and bring it back to the committee. Committee discussion, motions, whatever you'd like to go.
Mr. Chairman.
Yes, Senator Kinski.
Well, I'm going to go back to, it was either last summer or the summer before when we were in Sheridan, and what we heard from the judge at that time was similar to what we've heard today. The ask was fairly humble, which was in these cases where I know Judge Day used the word marginal, but I think other courts have struggled with that very concept. It's not a new concept. It's on page 8 of the Fuller memo, where parents can meet the minimal requirements of parenting. And that's where the real struggle is. And that's the cases they see most often. And the district court judge that we heard there said, is the law that they're either fit, not fit? And if they're fit, I got to give the kid back, and that's the end of the guardianship. Some of us read it that way. Or do I have the ability to kind of fashion a reintegration plan? It's not explicit in the law. Some of us as judges do that, depending on the circumstances, some of us not. So the ask was just for just some language added on to, just very briefly, that just spelled out what kind of remedial measures a judge can undertake in this case where the parent may or may not be rehabilitated, may be struggling, so that they can protect the kid in case the parent relapses. But if the parent truly is rehabilitated and this reintegration plan works, that parent has a right to their child. That's the end of the discussion at that point. But they just wanted to have some clarity in the law that they've got the authority to kind of fashion some relief or reintegration. And this bill goes way beyond that, I think. And I don't know how to fix it to get it to that. Probably we should have started with asking the judges to give us an outline of what they thought would really help. But I think this bill goes too far from the real issue that's being presented to us, as I understand it.
Okay. Yes, Representative Stiff.
Mr. Chairman, thank you. I have a proposed amendment. I won't spend too much time belaboring it.
We've got a motion to move the bill. Do we have a second? We finished public comment. Yes. So we've got a motion from Senator Nethercutt, second from Senator Anselmi. Representative Stiff.
Mr. Chairman, thank you. I have a proposed amendment. I won't spend too much time talking. It's similar to what I've mentioned in prior meetings on this topic. It relates to due process. I think we have to address due process because due process does provide heightened protection against government interference in certain fundamental rights and liberty interests, of which the right to be a parent is one. So the specific amendment, and I do have it in writing, but to start with the important part, we start at page 4, lines 10 through 13. And it proposes to delete lines 10 through 13 and to replace with the following: the court shall grant the petition unless the court finds that there is a compelling state interest in preserving the guardianship. The court shall deny the petition if there is a compelling state interest and it is in the best interest of the child to preserve the guardianship. It's the guts of it. That way the court has clear direction of what it's supposed to do, and we incorporate the notion of making it a specific finding of a compelling state interest, because I think if we don't do that, then we've got something that's unconstitutional, in my view. This amendment also includes some conforming amendments on page 2.
You want to put these together or do them one at a time?
I think that needs to be together because the conforming amendments just makes it consistent.
So this is all one amendment?
All one amendment, yes.
Where's your next?
Page 2, line 3. On line 3 of page 2, after the phrase interests of the child, delete the remainder of that line and replace with and determine whether there is a compelling state interest in preserving the guardianship, period. And then on line 4, just to preserve the grammar, we delete the phrase the child, and in front of, and also on line 4, in front of the words the court shall consider, have the phrase in making that determination. And the purpose of this page 2 amendments is just to make page 2 sort of consistent with the amendment on page 4.
Okay.
And that's the
Any questions on the amendment? Do we have a second on the amendment as proposed?
Second.
Got a second from Senator Hicks. Discussion on the amendment. Representative Winters.
Thank you, Mr. Chairman. I don't think it's discussion. I think it's just a question of would that then need to change some things in the enacting clause and different things. As far as making sure that compelling state interest is highlighted right up at the title. Maybe it's a question for LSO.
Senator Nethercutt, do you want to weigh in on that one at this point?
No, I'll let Alice
Okay.
answer the question.
Ryan.
Mr. Chairman, if I understand Representative Winter's question about the bill title on page 1, depending on what amendments are passed and what changes are made to the bill, we would change that bill title accordingly, unless the committee wants to specifically delineate what should go in that bill title.
Okay. All right.
Chairman.
Yes, Senator Kinski.
I'm against the amendment. I'm not sure that's really helping us much. Interjecting compelling state interest into the mixes, and in my mind causes more, not less, confusion. If the amendment we're talking about a threshold finding of fitness or unfitness, I think it would be more compelling. But as written, I have to oppose it. Thank you, Mr. Chairman.
Discussion on the amendment.
Mr.
Senator
Chairman.
Nethercutt.
Thank you. Just a question for Representative Stiff. And in response to Senator Kinski's comments and the concerns of of the public. Concerning this particular section, lines 10 through 13, just did you consider maybe instead of confusing the issue with compelling state interest, just to add it unequivocally to state that the court shall consider the fitness of a parent in making this determination? Just that statement, just unequivocally stated, so it was very clear for the court, very clear for the public what the standard is. You feel that's a different standard?
Representative?
I'm not opposed to including some finding that in order to grant the petition, the court would need to find that the parent's fit. I think that's kind of that's stating that would be clear. Doesn't bother me. I think that's sort of implied because the hypothesis, the whole premise of this is that you have a biological parent who at some time in the past was not fit because perhaps the parent was incarcerated. Now they're not incarcerated. They're now working. They're coming before the court asking to terminate the guardianship. So
would you like to, are you open to amendments, or would
Yes,
it be
certainly.
cleaner to restate the whole thing?
I'd call the question.
Question on this one. Take out.
and if I may, Mr. Chairman,
Your amendment.
we haven't talked a lot about, we've talked some about due process, but if we don't address due process at all, this bill is not going to survive judicial scrutiny someday. And so we have to have something in here, and the way to satisfy due process under Troxel v. Granville, I think, is to talk about a compelling state interest.
Question's been called. All in favor of the amendment as stated, two parts, two places in the bill language. All in favor, say aye.
Aye.
Opposed?
No.
Ayes, please raise your hand. And the noes, nay. And the nays prevailed. All right, that amendment fails. Just for the body's clarification, on the amendments, we'll just go with a simple majority, but for this bill to pass out of the committee, it's got to be the majority of both bodies individually. Okay, any other amendments or discussion?
Mr. Chairman, I have an amendment.
Senator Nethercutt.
Thank you. Page 4, line 13, after the word necessary, put a comma,
After necessary,
put a comma, but the court shall consider the fitness of the parent in making the determination.
okay? We're just adding at the end, but the court shall consider fitness. And a second. And so, whoops, go ahead, Senator Nethercutt, if you want to explain.
Yeah, Mr. Chairman, if I may, and just I would say a conforming amendment to add clarity to the bill in both places where this is addressed. So page 4, lines 3 through 10, as indicated on line 13. And then also on page 2, lines 1 through 5, that paragraph A. Whereas on lines 2 through 3, the court shall consider the best interests of the child as well as the fitness of the parent. So add the language as well as the fitness of the parent after the word child, just to make it unequivocal and very clear that is a required analysis by the court in making this determination.
Everybody clear how that's going to read on page 2?
Run that, Mike.
Yep.
Repeat that again, please.
So reading lines 2 through 3, the court shall consider the best interests of the child as well as the fitness of the parent.
Okay, that's been moved and seconded as amendment. Question on the amendment. Representative Winters.
Thank you, Mr. Chairman. I guess I just didn't have a question then on page 4. When it comes back to that same lines 10 through 13, the court may consider the factors of subsection A of this section without first making a finding of parental fitness or a finding that the guardianship is no longer necessary, but the court shall consider the fitness of the parent. To me, it seems convoluted, like it's actually the is now combating itself, the paragraph. I'm just trying to understand what that would do.
Senator Nethercott.
Mr. Chairman, thank you. I welcome any friendly amendments to clarify that. But the purpose is that instead of it being a two-step process, if one then go to two, it's a combined analysis. So instead of saying one, fitness only, then two, because that's what the law currently states, and that's some of the challenges presented, the court also has to analyze that in making that determination for that guardianship. Constitutional interests still apply to the court, and this statute doesn't trump those constitutional rights. And I think that's important in understanding how this bill interplays with the Constitution, with the Wyoming and U.S. Supreme Court precedents, that this does not trump any of that.
Representative Winters.
Thank you, Mr. Chairman. And I suppose the question is for Ms. Nethercott then. So in that circumstance, what is the difference between striking the entirety of that subsection B as opposed to just adding a comma and then the new sentence, but the court shall consider the fitness of the parent? What's the difference between the two if we were to strike it all together as opposed to adding?
Before we go on, and you can think about that, Senator Nethercott, Brian, Torrey, I see you're pulling mics over by yourself and you're whispering. Do you have some advice on how we may bring the two or the joint amendment together?
Mr. Chairman, I wonder if it would be simpler to strike subsection B, or delete, excuse me.
Where you at? Page 4?
Page 4, delete lines 10 to 13 and replace it with a new subsection B that would read, in addition to considering the factors of subsection A of this section, the court shall determine the fitness of the parent in considering the petition.
I'd like to make that my motion.
Sounds like a friendly adjustment to your motion. Oh, okay.
Just adopt that one.
All right. So the motion, I hear that the bringer of the amendment is liking that. Could you go back, Tori O'Brien, and read then the amendment in both places on page 2 and page 4 as it's been presented with this tweak?
So, Mr. Chairman, the amendment, as I understand it, on page 2, line 3, after child, insert, and the fitness of the parent. Then page 4, lines 10 to 13, delete entirely and insert subsection B. In addition to considering the factors of subsection A of this section, the court shall determine the fitness of the parent and consider deciding the petition.
Questions on this adjusted language on the amendment? Representative Olson.
Mr. Chairman, I guess I don't think it's any more fair. I'm a little more confused because what this amendment does is direct the courts to consider both parental fitness and the best interest factors. Or could make what I will just call a wonky decision, which would be to find a parent fit, but then apply the best interest factors and make a totally different decision. So that it is a totally different thing to require the court to consider fitness than to require the court to find unfitness before proceeding to court. So I don't think that that amendment is anything more than semantics. And if I'm wrong, I guess I would ask either for LSO or Senator Nethercott to correct me, but I think the result is still the same. I think right now the court can simply consider, well, this court already has to consider parental. It doesn't have to rest its decision on that one moving to the best interest analysis. And I think that's the question that this committee is actually wrestling.
Okay.
For clarification.
Representative Pelkey, you had your hands up?
Yeah, I just, in light of the changes that have been made, I just want to.
Okay. All right. Okay. Would anyone like to address Representative Olson's question?
Mr. Chairman.
Senator Nethercott.
Yeah, if I may, I think again, and I know I've said this a number of times, but I think it's important to understand where this bill is in the process That's on the termination of a guardianship, right? So it's and before an involuntary guardianship can be established, the court only looks at unfitness of the parent. And so that has been established. The court does not look at the best interest of the child at that point. It is only unfitness. If the court finds that the parent is fit in a petition for an involuntary guardianship, even if the parent is only marginally fit, the court cannot grant that guardianship. And so what this bill addresses is not that initiation of that guardianship, but at the end of it. So it contemplates after a period of time, typically years, that a child has been with a guardian, what that process looks like and what factors a court is to determine before a child's home is taken away, or it's the child's school. Before all of those things are taken away, the court is to look at, okay, this parent is coming back into this child's life. They're now in a different place than they were at the time this original involuntary guardianship was in place. But this child is also in a different place as well. And so the court needs to consider those factors as well of the impact that terminating this guardianship may have on this child. But that does not trump the child's rights, does not trump the parent's constitutional rights. Those are still preserved, and the court must take that into consideration. The court must follow the Constitution. And so what this does, though, is make sure that that requirement that the court does not overlook or obviate the need to establish and make very clear findings as to fitness as part of that analysis, but also doesn't ignore the fact, which is what the law currently does, that the fact that this child has been in someone else's care for a significant period of time.
So what I'd like to do is not to shut this discussion down. This is a great discussion. But before we go to the vote on the amendment, I'd like to invite the court to weigh in if they would like. And so just know that. But other questions or discussions on this amendment as it's been kind of redefined and cleared up by LSO?
Point of
Senator Kinski.
Yeah, just on against the amendment, I think it's a fine amendment insofar as it goes, but this whole bill, when we come to, it's just not ready for prime time. I don't see us kicking this thing out as a committee bill. It's too kludged together. I think the first 3 pages go way beyond.
We're still on the amendment, though.
I understand. I understand.
Okay.
It goes way beyond I think this amendment is still not going to fix the problem because the first 3 pages of the bill are still there. I think permissibly all we can do is a very narrow bill that says when a judge is faced with a parent who is or has been previously found unfit, that they can establish an integration plan, that they can order drug and alcohol testing, that they can order counseling, education, all towards helping to ascertain where this marginal parent is truly now fit. I think the last 2 pages of the bill are the only part that's salvageable.
All right.
So I'm on against the amendment.
Thank you.
Point of order.
Representative Stith.
Mr. Chairman, with respect to input from the judiciary, I think it's entirely appropriate and really very appreciative that the members of the judiciary make the effort to be here and to advise us about things that we've done or that we might do that could make their lives more difficult or make the cases they have to handle unworkable. But I also believe in the separation of powers, and judges decide cases or controversies. They don't issue advisory opinions. So I don't think it's a good use of our time to ask judges if they think a particular bill is constitutional or if they think it's frankly good policy. That's just not what judges do. I think it's important for us to know how it might affect their lives or how it might affect their cases. And I think there's a distinction there. So that's my 2 cents on that.
Thank you. Any other discussion on the amendment?
Question on the amendment.
Okay, we've had the question called on the amendment. I would still invite the judges if they would like, since we're spending a fair amount of time talking about this, how this impacts or their read on it, on the amendment itself. If they would like to weigh in on the effect of the amendment. And thank you.
For any parent who's previously.
Morning, Mr. Chairman. Marv Tyler. I'm a 9th Judicial District Court judge out of Pinedale, Wyoming. I guess there's a couple of things I wanted to point out for consideration about this bill. First of all, this doesn't,
That's too much to do.
Judge Tyler,
this bill would, oh, I'm sorry.
are we going to be able to keep it on the amendment?
Yes.
Out of respect for.
Yeah, yes.
Thank you.
This bill is something that would be required on every termination of a guardianship involving a child, whether it's contested or not. And so is there a need on an uncontested termination to make these determinations about fitness and about best interests? That's the first thing I guess I'd say. The other thing is there is in Wyoming statute 3-2-101 A Romanet 5, which is the petition to establish a guardianship, facts in the petition to show that the best interests of the proposed ward requires appointment of a guardian. So there is a best interest that's required to set one up. And I think this best interest could be left just as it's described in that statute without all these factors, that the court shall consider those factors. Maybe the court may consider those factors to determine best interests of the ward and termination of a guardianship. Those are a couple of comments, I guess, that I believe touch on this amendment.
Okay.
Thank you.
Thank you. All right, the question's been called for the amendment. All those in favor of the amendment, say aye.
Aye.
Opposed? The amendment passes. All right, we're back on the bill. Further amendments? Any further amendments? Any further discussion on the bill before we go to a vote? You have a question? Yes.
Call the question.
Call for the question.
We're going to vote on it today.
We are. And just a bit of clarity. In the beginning of the meeting, I said we were doing these bills and voting tomorrow. I was referring to the Justice Reinvestment bills. And so we are going to do a vote. And as a result, this will be a vote for each side, Senate vote and a House vote. And both sides have to carry the majority for it to go forward. And with that, do you have any questions of us at this time? Any from staff before we go to the vote? All right. How about roll call?
Mr. Chairman, this would be a vote for the committee to sponsor 19 LSO 26 version 0.5 as amended. Senator Anselmi Dalton.
Aye.
Senator Hicks.
Aye.
Senator Kinski.
No.
Senator Nethercott.
Aye.
Representative Beitman. Representative Jennings. Representative Olson. Representative Pelkey. Representative Pennell.
Aye.
Representative Salazar.
No.
Representative Stith.
No.
Representative Winters.
No.
Chairman Kirkbride.
Aye.
Chairman Christensen.
No.
Mr. Chairman, the vote in the Senate was 3 ayes, 2 noes. The vote for the House members, 3 ayes, 6 noes.
Okay. We didn't achieve a majority on both sides, so that bill will not move forward as a committee bill. Doesn't mean it won't be able to come forward as an individual bill, but it won't come out of this as a joint sponsored committee bill. All right, let's take we can keep it short. We'll shoot for 5 minutes if that'll get the job done. A quick break. Thank you.
I'm trying to, I don't. Yeah.
Children are chattel.
That paranoid. How you doing?
All right, folks, we're on judicial updates, and we've got a series of proposed bills that originated with the court. And with that, Tori, could you take it, or Brian, take us through these bills?
Mr. Chairman, I'll start with the first one listed on the agenda. It's 19 LSO 22. You should have version 0.7 in front of you. This is jury procedure amendments. The committee considered this bill draft at its last meeting. At the meeting, the judicial branch proposed a few amendments, and the committee directed LSO to incorporate those amendments into the bill draft for this meeting. Just by way of a summary again about the bill draft, it amends provisions related to the compilation of jury lists and situations where a prospective juror is not qualified or may be excused from serving. One change includes that a person may ask to be excused if that person is 72. And may be asked to be excused for the remainder of the term. The draft also provides for when a person has served on a jury for a term and provisions related to the composition of jury for criminal cases. In terms of the specific changes, Mr. Chairman, the changes that came from the judicial branch are listed in a staff comment on page 12. A number of the changes simply insert the word jury before term and insert the word base before jury list. There are also a couple of structural changes from existing language moving to a different section, namely on page 2, lines 11 and 13, and then a change on page 2, lines 17 and 18. That language has been tweaked as well. And Mr. Chairman, throughout the bill draft as well, there's a couple other changes that LSO suggests. For clarity, on page 6, there's a staff comment that suggests inserting an additional sentence that would read, a person who is discharged under this section is not required to appear in court, to provide clarity. On page 10, also wishes to note another change in the bill draft for clarity regarding the number of jurors for a criminal trial. That was changed from between 6 and 12 jurors, and that was changed to from 6 to 12 jurors to make clear that 6 and 12 are inclusive, as opposed to it being interpreted to mean 7 and 11, which are between that. And then, Mr. Chairman, there's another comment at the bottom of page 10 that proposes a change to the language that's currently on lines 17 and 18 of page 10 to where that would read the first 6 persons or other number of persons designated for a jury under 111, 119, which just contemplates that a jury may have less than 12 persons. And with that, Mr. Chairman, I'll be happy to answer any questions.
Questions, staff, at this point? Okay, from the courts on this bill.
Mr. Chairman, my name is Elisa Butler. I'm the attorney for court administration. I don't think I have anything to add to Mr. Fuller's explanation. I think anything to make anything, to clarify anything within that bill is great. So I don't think we have anything to add, but if there are questions, I would be happy to answer them.
Questions, Ms. Butler? All right. Oh, Mr. Co-Chair.
Yeah, thank you, Mr. Chairman. Ms. Butler, just to make sure I understand, on page 4, line 18, 19, and 20. So if I'm summoned to be on the jury and I'm one of the 40 people who show up and the attorneys kick out 6 and pick the other 12 and I'm one of the 20 that just goes home, then I can consider that I've served that term. I could apply for an exemption or I'm just exempt. So that counts as serving on the jury if I just showed up.
Please.
Mr. Chairman. Mr. Co-Chair. So the language, yes, provides that if you have been summoned to serve, you are you can request to not serve for the next jury term. So yes, that would be correct, the way you explained it.
All right. Any other questions? Thank you. All right. If you can go ahead and wait there if you'd like, because we moved through this, but public comment, or excuse me, agency comment on this bill. Any other state agencies, local government? Yes, Judge Day.
Mr. Chairman, committee members, the only thing that caught our eye, I think, was on page 8, 111, 116, lines 13 and 14. The words "and notified" are added to summoned, and then in the next line, the names of those jurors notified to appear. And we're wondering if that means the same thing. There's a rule of criminal procedure 42 that says that if a juror who is properly summoned does not appear, then they can be held in contempt of court. And notified doesn't, I'm not sure it's clear that notified means the same thing as summoned, and how that would coexist with that rule of criminal procedure.
Good. Questions of Judge Day? Comments? To our staff, do you have anything for the committee relative to Judge Day's concern? Not yet. Okay, thank you. Anything else, Judge Day?
No, thank you.
Okay, appreciate that. All right. Any other state or city, county agencies would like to speak at this point on this bill?
Mr. Chairman, if I may,
please
speak to Judge Day's question. The reason for the difference in the language there, the clerks of court take essentially they have two different practices throughout the state. Some courts will send out summonses when they initially send out the questionnaire, and then because those courts are so busy, like Laramie County, what they will do is they will then notify, so the summons has been sent in accordance with the rule already at the very beginning of the jury term, and then the jurors will be notified, and they will be notified sometimes by phone. With the new agile jury system, the new jury management system, they can be notified by email or by text message to come to jury duty, to show up at the court and actually serve on that jury. And there are some courts who do send the summons with every jury trial. And really, it's just a difference in the way that the courts handle those juries throughout the state. Some do them in the one step where they send a summons out at the very beginning of the term, and some will send out the summons before they have the actual jury trial. So it just is dependent upon court. And so we wanted to provide a little bit of flexibility there for the clerks to be able to maintain their processes.
Thank you. All right. Agency comment. Any other agency comment? Public comment on this bill? Is there any public comment? Public comment. Comments closed. Back to the committee. What's your pleasure? Got a motion from Senator Anselmi.
Second.
It's close. And a second from Senator Nethercott. All right. Is there any amendments, discussion before we go to the vote? How about the roll call?
Mr. Chairman, I don't know if the committee wants to consider the staff comments throughout the bill draft or not. It's certainly up to the committee.
Yeah, we didn't really, I apologize, we didn't work the bill. As far as those staff comments, you had, let's talk about.
Page 10.
And Mr. Chairman, if you'd like to go over the first one,
Let's do that, Brian, if you would.
On the top of page 6.
Yep.
That would be an amendment to page 5, line 19.
Okay. On the page 6 on staff comment, is there a desire for
Mr. Chairman,
action?
I'd move that we adopt that as an amendment.
A motion to amend and a second? Question on being called? All in favor of the amendment as proposed on top of page 6, say aye.
Aye.
Any opposed? That amendment passes. Brian?
And then, Mr. Chairman, the only other item I believe for action would be at the bottom, the staff comment at the bottom of page 10.
The 7-11 versus 6 and 12.
I'm sorry, Mr. Chairman.
Yeah.
Yep.
Got a motion to amend?
Second.
And a second. And this is the new language that just clarifies or clears it up on the bottom of page 10. Any discussion on the amendment? All in favor, say aye.
Aye.
Opposed? That amendment passes also. Is there any other, before we go to the roll call, discussion, concern, or amendments? How about a roll call, please?
Mr. Chairman, this would be a vote for the committee to sponsor 19 LSO 22 draft point 7 as amended. Senator Anselmi Dalton.
Aye.
Senator Hicks.
Aye.
Senator Kinski.
Aye.
Senator Nethercott. Representative Beitman. Representative Jennings. Representative Olson. Representative Pelkey.
Aye.
Representative Pennell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Winters.
Aye.
Chairman Kirkbride.
Aye.
Chairman Christensen.
Aye.
Mr. Chairman, the motion passes.
Thank you. All right, Brian or Tori, if you take us into the next bill.
Mr. Chairman, the next bill is 19 LSO 107, expungement of juvenile court records. This bill amends existing 14.6 241A, and its main purpose is to accommodate or account for electronic records. And in that vein, on page 2, lines 12 and 13, inserts after all records in any format, including electronic records. At the bottom of page 2, lines 21 and 22, this is really just clarifying language. It does not change the meaning of the existing language. However, we LSO believed it was a better language, inserting a minor convicted of a violation of a municipal ordinance may be expunged. Moving to page 3, lines 4 through 9, there's created a subsection D. This subsection specifies that a minor who receives a deferral or other diversion program that record can be expunged in the same manner as provided in subsection A. So this is actually a new section that clarifies deferrals and diversions can be expunged. Page 3, lines 11 through 17, create a new subsection E. Similarly, that this provides, and again, I think this is more in the vein of clarification, but makes it explicit, provides that records of arrest charges that resulted in the dismissal or decline of prosecution may be expunged in the same manner as provided in subsection A. Finally, at the bottom of page 3, lines 19 through 23, and then the first 2 lines of page 4, there's created a subsection F. Subsection F defines what expungement means in this section. And I should note that there are other sections of adult criminal procedure that have a separate definition. But for the purposes of this juvenile expungement, expungement means to permanently destroy, delete all records, including physical and electronic records, documents, and images of documents. It also provides for the scenario where a minor's name appears on a list that is not particular to that minor's case. So it provides if a minor's name appears on a court list, index, or other compilation containing other information not subject to expungement. Expungement means to redact by obliterating the minor's name from the record. On page 4, lines 4 through 8, there's created a new subsection G. This subsection requires that no record can be maintained after an order of expungement, except as provided in Romanettes 1 and 2. And the committee may recall discussion, I believe brought up by DFS at the last meeting about federal reporting requirements. Romanet 1 attempts to address that issue by allowing an agency to retain records to comply with federal reporting requirements, but they shall not be otherwise disclosed or released. And they shall be expunged within 10 years after the completion of the initial court case. Romanet 2, lines 17 through 23, is the second exception. And this exception arose out of the discussions, I believe, with the Court Administrator's Office and perhaps with DFS about electronic records and what that actually means. There apparently is a sophisticated backup system in most databases that would require an inordinate amount of time to delete those, and those are not accessible ordinarily until they are restored. So this provision allows that backup databases that aren't accessible do not have to be immediately deleted, but they have to be deleted upon restoration. And it requires that any law enforcement, court, or state agency implement policies to ensure that expungement occurs according to that directive. On page 5, there are two amendments to 14.6.440, and that is the provision that is in existing law in the Juvenile
on the same draft
title, the expungement of records in juvenile court, and it simply on line 13 and 14 adds electronic records and lines.
Story. Well, the page numbers are not matching up to what we have in our hands. I don't know if we're all looking at the same thing.
Did I should be talking about page 5, maybe. Working draft 9.
Yours matches? Oh, I have the one with staff comments. You have the one with staff comments? Some of us are looking at different editions. The content's right, but the citations are different. Come on, Steph.
Oh, okay. Thank you. So, yeah, and thank you for bringing that up, Mr. Chairman. Handed out, I am working off of a working draft number 9 that was in your binders. What was handed out this morning by staff is proposed amendments that we are not on yet, proposed by Representative Pelka. So that's why that's not matching up.
Thank you.
So on the bill that's in your binder, I'm working on page 5, lines 13 and 14, electronic records are added, and 20 and 21, just the addition of the language expungement pursuant to this juvenile section shall be accomplished as provided in section 241. With that, I'll stand for any questions.
Senator Hicks.
Mr. Chairman, Tori, just for edification for my part, so when we bring in the new language in page 3, subsection D and subsection E, it both references that this section, as we go in there, it says of this section it says same limitations as provided in subsection A. So the question I have is the language in subsection A. So if we go back to that, and you go to line 11. So basically, this is where we get to the expungement portion, but it says in here it has to be, so as long as the youthful offender has met all the requirements, but it says has been attained to the satisfaction of the court or the prosecuting attorney. So for my edification, is it one or the other, or is it both? Does it have to be the court satisfied or just the prosecuting attorney satisfied? And what happens under the scenario where there may be a disagreement between the prosecuting, because it's an or, not an and. So can you help me understand that?
Please.
Perhaps, Mr. Chairman, Senator Hicks. First of all, let me point out that this is existing language.
Yeah.
We did actually take notice of that when we were amending this bill. That language goes back pretty far. I forget if it's the mid 70s or 80s, but it goes back pretty far. And the or prosecuting attorney was added at some point by an amendment. And again, I apologize, I don't remember the exact year, but it appears that that is an either or, and that if the court does not believe that the rehabilitation has been attained, but the prosecutor does, I think the language of the statute as it exists now contemplates that it will be expunged. That's something of a prosecutorial veto over the judge, I think. But again, that's existing language. We haven't changed it.
Okay. Sounds like a conversation to come in a little bit.
Yeah, I don't want to ask that question.
All right.
Judiciary as we get into public testimony.
Okay, Tori, anything?
I'll stand for any other questions.
Hey, Representative Stitt.
Mr. Chairman, I wanted to ask staff how the expungements of deferrals under, I guess it's on page 3, proposed subsection D, how that relates to, say, the teen court program, where existing statute requires that if you successfully complete the teen court program, that an abstract of that has to be sent to the Department of Transportation. So does this trump that, and is this a directive then to the Department of Transportation? I mean, does it affect that at all? I don't know. I'm not sure what the effect of this language is.
I believe that under the language of this bill, if that is expunged under the new 241, that the Department of Transportation would be an agency that was required to expunge that record.
Okay. Committee, any other questions from staff? Yes, Representative Winters.
Thank you, Mr. Chairman. I'm asking this question on behalf of an individual that called me, a constituent of mine who's listening today, and they just wanted to ask for me to ask the question on page number 4, paragraph Romanet I. When it comes to the federal reporting requirements, they just wanted to know what that was. In the previous subsection, it says no record of the minor's identification may be retained by any law enforcement agency. So they just wanted to know what the federal reporting requirements may be. And when I have a young individual call me, I just like to make sure that happens.
Tori or Brown, would you like to answer that, or should we invite Patty in?
Mr. Chairman, I think that was a discussion that perhaps was first raised by Ms. Schmidt from DFS. And I think DFS had some reporting requirements that they were concerned about.
All right. How about if we're done with this point, we can get that answer in just a second here. Any other questions of staff based on this introduction? All right, let's come back to Bennett. Would you like to go first, or could we answer that question immediately?
If DFS wants to answer that question, that's
Thank you.
fine, Mr. Chairman.
Come on up.
Thank you, Mr. Chairman. My name is Corin Schmidt. I'm the Deputy Director for the Wyoming Department of Health, Interim Senior Administrator for the Department of Family Services. Mr. Chairman, members of the committee, that was an issue that we brought up at the last Judiciary meeting. We have a case management and claims system called YCAPS, and it's through that system that we are able to track individuals at the case management level. However, that's also where we track when we have services provided to children that are eligible for 4E reimbursement of funding. So in that scenario, we need to retain some records, and we had discussed about a 10-year time, so that in the event that we get audited by the federal government, we can document that that child indeed was eligible for that service, and then that service was eligible for reimbursement. So that's the first situation that we discussed. The second situation is that we also report to the Administration of Children and Families non-identifiable data. So we send data sets, kind of a minimum data set, to the federal government. It doesn't include any of that information, but in order for us to, if we were to delete that information, then we would send one report, delete it, and then send another report, and then there would be some discrepancy in the data. So, Mr. Chairman, that's the reason for the request.
Thank you, Ms. Schmidt. You are welcome to stay up here for a minute if you have more, or we can go on to the court.
Mr. Chairman, while I'm sitting up here, we worked with the Supreme Court on the language of this bill, and we're satisfied with it. It meets our needs, and so we're supportive if it continues on.
Thank you.
Thank you, Mr. Chairman. The purpose of the changes to this bill,
For the people out in the
I
listening
apologize. My name is Patricia Bennett. I'm the clerk of the Wyoming Supreme Court. The purpose of this bill amendment was to take an existing bill which allows a juvenile, once they've reached the age of a majority and they've been rehabilitated to the satisfaction of the court, to have the record expunged. And the existing language allowed that young person to answer as though the event never happened, and that's existing language in here. And so what these changes are intended to do is to make that a reality, so that expungement truly means that the record is gone. They can't, they won't at some point later on answer a question, no, I have never had this charge or anything, and then have that employer, that school, whatever, go back and actually find a police record or something and put that young person in the position of having to explain themselves where it looks like they've been dishonest. That's the purpose of all of this. The last time we met, there were two concerns. One was the Department of Family Services concern, which you've already heard about. And so I believe we've addressed that to their satisfaction. They do have reporting requirements. And so we've tried to put language in that addresses that, but it still protects the young person. The other concern was in the Supreme Court and the courts maintaining electronic systems. There are backups created of those systems. And when we get to electronic filing and more electronic records, that's going to be an issue. Those systems are created, backups are created. And so we wanted to be able to address the concern that there's a backup of that record. It may be expunged by the district court or the circuit court, but yet that backup still exists. And so the language that we put in would allow that backup to still exist. If for some reason there's a loss of data in the court, then once that backup is restored, then it is required to be expunged, but not before. We don't have to go back through those backup systems because I believe that would be cumbersome and really quite difficult for us to be able to do. So those were the two changes. And I think Representative Stith asked about the Department of Transportation. My understanding, and Mr. Racines can certainly jump in, but my understanding is that Department of Transportation is an agency, and once that record is expunged, Department of Transportation would be required to comply with that expungement order as well. Again, I think it's important to remember that none of this is going to happen until the young person reaches two milestones. One is that they reach the age of majority, and two, that they have been rehabilitated to the satisfaction of the court or the prosecutor. So with that, if there are any other questions, I think we've talked about this bill quite a bit. So if the committee has any other questions for me, I'd be happy to address those.
Okay. Questions, Ms. Bennett? Yes, Representative Pennell.
Mr. Chairman, thank you. Bennett, on isn't there another requirement that they have to go before the court to ask to have it expunged? It isn't automatic. I'm trying to look at this because of the simple fact that if it's automatic, I'm just curious how many people are going to have to be looking at some of these things in law enforcement and things of that nature to expunge all those records without an order coming from the court.
May I?
Please.
Senator Christensen and Representative Pennell, yes, there is a petition required. This is not an automatic process. And so the court does see that petition, and they do have to actually look at that petition. And, you know, anecdotally, based on my own experience, I have done these by paperwork where the juvenile doesn't have to actually stand in front of the judge. And I've done one or two where the judge has wanted to see a hearing. And I think that's up to the individual judge. You know, maybe if they've small towns, people know kids and everybody else, if they want to see this kid, then that certainly can happen, or they can be done by petition, but they do have to ask for this. This is not an automatic process.
Any other questions at this point of Ms. Bennett? Thank you. Do you have anything else to add?
No, sir.
Okay. Appreciate that. All right. Let's go to state agencies and county, local government. Come on up from the Attorney General's office.
Thank you, Chairman. I'm Kara Chambers with the Attorney General's office. Just wanted to, and I apologize because I have not necessarily addressed this with the court. I was able to speak with the gentleman at DCI. They had just had some minor concerns. They wanted to point out that by and large, DCI does not house juvenile records. So largely this statute wouldn't affect them. But if you turn to page 3, the newly inserted subsection F, there was just a little bit of concern on how broad that could be interpreted and what it would mean. For example, if you had a wiretap, for example, that maybe ensnared a juvenile in some manner, what is that to mean to obliterate the minor's name from the record? Just kind of throwing that out there. This is something that DCI raised. Just some concerns on how broad removing all electronic records could be. I don't know if that's something that could be kind of included in page 4G, Romanet numeral 2, when we're talking about like backup, you know, if it's more akin to backup, like this is not stuff that we're actively getting into, and just pointing out that it could be onerous to obliterate a minor's record.
Bring a concern, but no solution.
Yeah, no, that's your job.
Okay.
So just here to bring a small wrinkle. That's all.
All right. Ms. Bennett, you have any suggestions for us?
No.
Okay.
Just doing my due diligence on behalf of the agency.
All right. Appreciate that. Anything else?
I do not believe so, sir. Thank you.
Okay. All right. Any other state, county, city agencies before we go to public comment? Mr. Odekoven?
Thank you, Mr. Chairman. Byron Odekoven, representing the Wyoming Association of Sheriffs and Chiefs of Police. Let me quickly address the point that was just raised. I believe the bill contemplates records of juveniles, i.e. a court action, a citation, a charge, a expungement of a record. So I would guess that a report, as was described, a wiretap, which may contain the name of lots of people in it, none of them have a record. So in my interpretation or our look at that, I'm guessing that a name in a report is not a record for purposes of a court discussion per se, because it's not a criminal side of the house. Otherwise, we would be running through lots of paperwork to remove people's names when it is not a crime. It's we went there, it was the accident, we went there, it was the loud dog call, it was the who called in the rabbit that was dead in the road. It would be an all-encompassing discussion above and beyond where I think we are with that of a court record, a court action that we're now expunging for purposes of job applications as we were talking.
Okay. To Tori O'Brien, over on page 1 under the description, there on line 10, it says related to agency and court records. In the body of the bill, proposed bill, does it talk about agency or just court?
Mr. Chairman,
on page 1?
Over on page 1 on the copy I'm looking at, line 10, expungement provisions relating to agency and court records. But farther in the body of the bill, that's a description. Is agency, do you guys see that anywhere?
Mr. Chairman, on page 2, so in subsection A, it'd be lines 13 or 14. It's official language. It provides the court shall order or expunge all records in the custody of the court or any agency or official pertaining to the petitioner's case. So that, I believe, is where, and that is existing language, Mr. Chairman.
Okay. Does that answer your question? You happy? Excuse me, Mr. Monaco. Not really.
Mr. Chairman, or slightly more confused, but nonetheless, we'll look at that a little bit. And then the second half that I rose to discuss is I did raise the question earlier in the earlier testimony about the maintaining records is for purposes of federal reporting. And we do not keep the person's name for doing the Uniform Crime Report, or now it will be transferred to the NIBRS, National Institute-based reporting system. But we do have to have that record of how many juveniles or adults, for that matter, did we encounter in of these, and need to have that substantiating record again, much like DFS. We can't report that we had 6 homicides this year and then turn around next year and say, by the way, we only had 4 last year. Doesn't quite jive. We'll have to make sure that the record that we maintain for purposes of reporting satisfies the desire to say no in terms of a record, but protects the integrity of our actual reports on behalf of the state of Wyoming.
Ms. Bennett?
Thank you, Mr. Chairman. I'd like to address 2 different points. The first was the point by DCI. And I think it's important to remember that that petition that goes to the court is incident specific. So it is something that if this juvenile was brought in on a charge, and if that person has 5 different charges and they have a delinquency, maybe they have something in circuit court, maybe a municipal, they have to ask for each one. And to have those, and they can ask for each one in one petition, but they do have to specifically identify what it is they are asking the court to expunge. So the idea that, they are getting one thing expunged, but their name may have come up in something entirely different. I don't think that is really an issue. I think that the expungement as it is written and in practice it's related to an incident that results in a delinquency before the court or a charge before the circuit court. So I think that although I appreciate DCI's concern, I don't think that they're going to get an expungement order that says anything that this child has ever been mentioned in ever. So I don't think that, I think those are 2 different things. And I think this bill does not really I guess, will not really cause that particular issue. And then I guess that may be the same issue that Mr. Odakoven is also concerned about.
Okay. Any questions of Mr. Odakoven? Please, represented by.
Thank you, Mr. Chairman. Mr. Odakoven, on page 4, line 4, does subparagraph G of hamper law enforcement in any way? I'm thinking of in a case where you know, is this dealing with your internal records? If you had a run-in with an individual, are those deleted if the record is expunged? And if this person were to go on and commit a different crime, are you able to bring that pattern? Are you able to build a pattern of behavior, or is that pattern of behavior deleted in your internal reports at the sheriff's office or something like that? You see what I'm saying? So can you address that for me?
Mr. Odakoven?
Mr. Chairman, I believe the intent of the bill is that record, that previous act would disappear and the new act would stand on its own. And if the judge remembered the previous act may have a bearing, but we would not be able to report on the previous act because the previous act disappeared, if I understand correctly.
Any other questions? Mr. Odakoven, thank you. Would Mr. Kaysen?
Thank you, Mr. Chairman. Rick Kaysen with the Wyoming Association of Municipalities. Mr. Chairman, with your permission, I do have a handout that I would like to provide to the committee, as well as LSO, and some copies for the public, and then we'll explain that and we'll see how much depth we wish to go into this, sir.
All right.
Yeah.
Staff, help us here.
Mr. Chairman, if I may, while this is being handed out and for the public's awareness, because there's not enough copies for all the public, what is being handed out is a letter from a gentleman by the name of Marc W. Harris. Mr. Harris is an attorney in Wyoming. Excuse me. He is WAM's legal counsel. He also serves as a municipal judge for 4 of our municipalities. And those municipalities are Evanston, Mountain View, Lyman, and Diamondville. So I requested of Mr. Harris his view, an overview of this bill, and his reaction, not only from the perspective as WAM's counsel, but also as a sitting municipal judge, and what this would mean in the day-to-day operations for a municipal judge as well. Mr. Chairman, I don't know if you wish to go into detail of Mr. Harris's comments. For the public, it's just a little over 2-page report back to me.
Can you highlight it?
Yes, sir. That would be the intent.
Thank you.
Excuse me. And with those highlights, sir, I would ask to turn to page 2 of Mr. Harris's, or Judge Harris's, letter. It would be the second paragraph on that letter. And he addresses a proposed addition of subsection F that appears to implement a specific definition of expungement. This definition appears to him at odds with Wyoming statutes 7-13-1401 and 7-13-1501. His recommendation, and this was discussed by LSO just a little bit, about the separation or the difference between juvenile expungement as well as adult expungement. And Judge Harris suggests that this the expungement could perhaps be consistent with what already was on the books for adults. His second comment, the language of subsection G of the bill raises some concerns. First, the specific subsection appears to apply to law enforcement agency records, And he notes that there is no control by municipal courts over the law agency records. And again, I think that is just a comment from him about the control on that. But again, our law enforcement in our municipalities works closely with the municipal courts as well. Next comment is subsection I of the bill, and he states that this is somewhat confusing. It permits an agency to retain records to comply with federal reporting requirements. However, at lines 13, 14, and 15 on page 4 of the bill, the language seems to require an automatic expungement after 10 years from an initial court case involving a minor. Excuse me. He goes on to state that this language should be clarified to reflect that if a request for expungement is made relating to the records kept for a federal reporting requirements, that not earlier than 10 years after completion of the initial court proceedings, then those records kept for the federal reporting requirements could also be expunged. Finally, subsection 2, Romanet II applies to a law enforcement agency not under the direct supervision or control of the municipal court. Again, back to the ownership of the records. Subsection requires agencies and courts to implement policies and procedures to ensure expungement of records occurs after the restoration of the backup of the databases, which we've already discussed as well. And in his opinions, that language in lines 20 through 23 of page 4, they would be deleted. Mr. Chairman, those are the highlights of Judge Harris's comments, his concerns as well, and what could be considered as potential amendments. Overall, WHAM, of course, is in favor of this bill, just perhaps some clarity as it goes forward.
Okay. Questions of Mr. Casey? Thank you.
Thank you, sir.
Relative to this memo, Ms. Bennett, do you have any feedback or words of comfort?
Just a couple of comments, Mr. Chairman, and I think we've made this clear in our other meetings, is that it absolutely is different than the adult expungement bill. That's a completely different animal. We're talking about our juveniles, and I think we've commented quite a bit on that. I'm not going to belabor that point, but yes, it does. It is different than the adult expungement laws, and intentionally so. With regard to law enforcement records, the existing language and what the new language adds some clarification, but the existing language says that the court shall order expunged all records in the custody of the court or any agency or official pertaining to the petitioner's case. And so the existing language already requires the expungement of records in the custody of any agency or official. Certainly most law enforcement and they have agency right in their name. They are agencies, they are officials. So that already exists. That's nothing new. And then with regard to the electronic records with backup databases, the intent of that was the records stored by the Supreme Court, because we do have backup records, and I don't think that adds any additional burden. If the committee has any further questions, I'd be happy to address those.
Committee, relative to these concerns? Yes, Representative Snell.
Mr. Chairman, thank you. Just a quick question. If it's already in place by current law, why are we drafting more paper?
I think that the intent, and we'll go back to that, is that, law enforcement, we put law, or I guess, I should just take ownership. I put law enforcement in there specifically to address the scenario where something falls through the cracks and a law enforcement agency doesn't expunge a police report that's related to something that juvenile ended up coming up on charges on. And then a background check is done, and that police report's released. And I think that's what it's intended to do, not intended to address investigations and things that don't result in any kind of charge or anything else.
Please follow up.
Mr. Chairman, my understanding that law enforcement does not release juvenile records for background check as far as to somebody looking for employment or things like that. I don't believe they would release that. I just find it hard to believe that we're tying them in there now because it's a known fact. They don't release minors' records.
Which is, may I?
Please.
Which is good. And again, it's just to add that assurance and to make sure that they are included and that it's very clear that everything is included in this. And I think that also addresses the point that Mr. Odekoven made earlier is that, and I wrote that down on my notes, is he had some questions about, well, what if we, the minor's name just happens to come up. And if it's not released, then it doesn't matter. But if it is released, if that's my understanding of how law enforcement agencies work is they don't necessarily release their notes. But if something's in their investigatory notes or something that comes up on a wiretap or something else, that's not going to be released anyway. But this is intended to address things that might be released. And they shouldn't, in my humble opinion, shouldn't be releasing anything related to juveniles, but this makes sure that nothing related to a juvenile is released. So it's just that additional assurance.
Okay. Any other questions? Mr. Odekoven, what's the practice as you know it as far as military recruiters when they come in with the signed tell them everything I've done statement?
Mr. Chairman, Byron Odekoven again. I think the last half of your question answers the question. If we have a signed release to release, we release.
Including
we do not
juvenile.
have a signed release for the juvenile who's now applying, who signs with his parent usually to please release all records. We release all records. Now, if it's expunged under this discussion and it doesn't exist anymore, then we would say it doesn't exist anymore.
All right, thank you. Other state agencies, county, city, government entities would like to weigh in on this bill? Proposed bill? Public comment. Is there any public comment? Machine.
Mr. Chairman, members of the committee, I'm Donna Sheen with the Wyoming Children's Law Center. I just want to speak in favor of this bill and remind some of you who've been here for a while that this has been a difficult issue that we've been trying to wrestle with for many years. In response to Representative Pownell's concern, I would just say or remind the committee that most of the juvenile charges in Wyoming, remember, are in adult courts that are public records. So we're a little different, and your expectation normally is that juvenile records are all confidential, but that's not true in Wyoming. So, for example, if a law enforcement officer issues a citation to a youth, maybe while they're at school, that is generally a citation into a municipal court or a circuit court, one of the adult courts. So it is a public record under our current laws. What may happen is the prosecutor may decide to take that as a juvenile court action, and then it will be transferred to juvenile court and it could become a confidential case. But typically, that's not how it's happened. And I would say more and more prosecutors are doing a wonderful job of diverting most of these youth from any court process, which I think is really commendable. But the problem is the record still exists. So once a citation, and especially now that there are e-citations, that record is created and it is a public record that lives out on the internet and everywhere else forever and ever. And what we're trying to do is make sure that there are avenues, reasonable avenues for juveniles and families to be able to get those records back and remove that when it's appropriate. And I think this bill goes a long way towards solving that. I certainly think if there are concerns about investigative records that are otherwise confidential, that could be worked out. I will say that in response to that concern about investigative records, I think that's again somewhere where counties and communities differ on how they handle that. I know, for example, that in Laramie County, I believe their municipal court still has an ordinance that does make those juvenile records confidential, and they can't be released to anybody who wants them. But not every community has done that. In fact, I think that's the exception rather than the rule. And that's why it's so important, I think, to keep working on this. And I would also just speak in favor of, I believe Representative Pelka will be bringing an amendment that will also help prosecutors, because oftentimes they're offering diversion to most of the youth who come in contact, with them and are charged with something. And so everyone operates as if, okay, we're going to divert it, and it's going to be something where you do something that will show us that you've made amends, repaired the harm that you caused, and we're going to dismiss the case. But what, unfortunately, right now, what happens is the citation was already issued, it exists, and even if you have a dismissal, it still remains on that record. And so when somebody's going to see it, maybe in a job interview or a background check, and they're going to ask you about it, and if you haven't taken the steps to expunge it, then you're going to have to say, yeah, I did that. You're going to have to say, I did diversion, and then they dismissed it. So I think what Ms. Trent had asked for last year in a separate bill that I think would be wonderful to incorporate here is giving county attorneys who run diversion programs the opportunity to also, as part of the diversion and the completion of the diversion, simply take care of that expungement right then and without further expense. So I would encourage you to really consider that as an option as well. And with that, I would stand for any questions.
Any questions, Ms. Sheen? Thank you.
Thank you.
Any other public comment, sir?
Tyler Smathers, student at the University of Wyoming and previous fourth grade teacher in Casper, Wyoming. I would just support this in a beneficiary of expungement, in which I plead the fifth, but
now, those rules don't apply here. We're expecting full reveal.
Yeah, so they weren't serious in nature, but in order to, rehabilitate and instead of getting caught up in the justice system and having those repercussions come up over and over, I would, and in Ms. Sheen's comments, also the diversion program of automatically expunging those records would be helpful. So because I know of several people that have been immature in their youth, but have gone on to live productive lives. I would just support this in my own testimony of the benefits of being able to move on with life, move forward. And thank you, Chairman Christensen.
Thank you. Any questions of Mr. Mathers? Thank you, sir. And congratulations. Public comment? Anyone else? Yes, ma'am. All that we're on public comment. You missed your opportunity.
Oh, okay.
No,
sorry.
I'm just kidding. Oh, we're glad you're here.
Okay.
Ms. Trent.
Really?
Yes.
Mr. Chairman, my name is Peggy Trent. I'm the Albany County and prosecuting attorney, and I'm in support as the Albany County attorney for this piece of legislation. I would like to share with you, in Albany County, I know that when we have expungements right now with juveniles, we're having some difficulties because of our antiquated computer system and the way records are stored right now. We have trouble deleting and getting rid of those records. And also we have records that are archived over in through the state archives right now. So we have a process where we are actually having an Excel spreadsheet at times in order to kind of cumbersome to make sure we don't violate the rule, the order when it happens. Also, I've noticed with some of these petitions and orders, they're not naming some of the attorneys in the forms. There's not templates, and they're not naming the correct agencies to do the intent of the statute to get rid of all of these different records I've noticed. And so I would just bring to your attention, I'm supportive of anything for clarification for law enforcement, my office, or how we would handle that process. I think this would be the start of the dialogue. We're going to have to figure out how we're going to, we're doing it now, but we need to do a better job in how we're doing the electronic versus the paper copies. And also, as you well are aware, Senator Christensen, previously in the last legislative session, I think there may be an amendment coming later. Right now, it is incumbent upon a child or their parent to file subsequently to do these petitions. And I was asked last legislative session some questions, and if I may, explain to you that I don't represent those children when they get in trouble. So it's if they are unrepresented, which many of the kids are unrepresented going through our diversion programs, they don't know the process and how to work through it to get their record expunged. And I'm not supportive of automatic expungement in any manner, shape, or form, but I am supportive of a process that we can assist through the state prosecutors if we decide as a prosecutor to file a petition in a matter with diversion cases. Right now, we are getting records for kids turning up in NCIC for children, but not for certain adults on certain cases that are misdemeanors. And it seems like kids their records will file when they go across the border, when they become older. We're seeing a lot of this activity that is occurring, and children think when they go through the diversion and it's dismissed, it's done and they don't have to worry about it, and it's coming back that we're seeing it. So I would respectfully request that I support this bill, and what it's going to be also just as cumbersome in general for us as we work through the system, but would request that there be amendment to allow a prosecutor to file when they feel on certain cases. Thank you.
Thank you. Any questions of Ms. Trent? All right. We're good. We're good. Thank you. Is there any other public comment? Closed public comment. Back to the committee. Committee discussion on the bill. Whoop, got a motion. Got a motion and a second? And a second from Representative Pelka, second from Senator Anselmi. Discussion on the bill.
Question.
Okay. Chairman.
I think there's some amendments. Good move. Senator Hicks.
Mr. Chairman, I just want to go back to the subsection A question I'd asked, and I'd ask staff to look up, because I think you and myself being the longest serving members on this, we had an extensive discussion on this 4 or 5 years ago at Cody when we were looking at expungement for adults with nonviolent felonies. And I distinctly remember that the county attorney and the prosecutors there discussing this or provision within statute. So I had asked staff to see what the language is that we settled on with the adult expungements for felonies, because we did have a protracted discussion as to what that meant and how that played out. So if I may.
Please, Brian.
Mr. Chairman, for the adult expungement, just getting to the relevant provisions, any petition that's filed has to be served upon and reviewed by the prosecuting attorney. And then no order granting expungement can be issued before 20-day period. And then within that 20-day period, the prosecuting attorney can file an objection. And if an objection is filed, the statute requires the court to hold a hearing. If no objections filed, then the court could summarily enter an order of expungement.
Senator Hicks.
Mr. Chairman, I think it would probably behoove the committee to consider changing subsection A to make it consistent with our expungement provisions for adults for nonviolent felonies, so that we have the exact same process involved. I'm just overly cautious here that the way the language reads now, I'm not clear when it says or, that that's going to be interpreted across the board in every court the same within the state of Wyoming. I think what we did on the adult side is pretty clear that those prosecutors are going to have a little bit of say-so. My recollection of the testimony there was sometimes the prosecutors have much more information available to them that the court may or may not have as part of the investigations that sometimes they can bring to bear. Plus, there's a checks and balances system that we have provision. In other words, I think the prosecutors are more interested in representing the interests of the state, and sometimes the court's looking at the interest of the individual. So I just think there is a checks and balances system that when we put the provisions in that we did for the adult expungements, that actually makes for a better process than sets up this discretionary or. So, Mr. Chairman, I would make the motion that we take the language out of the provisions for the adult expungement that Mr. Farmer just read and bring those in there in subsection A.
Okay, so you're talking about, and make sure we're all looking at the same document on page
2.
I know, I'm looking at his.
Page 2, line 11, it talks about the satisfaction of the court or the prosecuting attorney.
Okay.
What I'm saying is again, this is existing language, but we spent extensive amount of time when we looked at expungement for nonviolent felonies. And that was the language that we settled on that seemed to satisfy both the courts and the prosecuting and county attorneys at that point in time. I just think it would behoove us to have exactly consistent language instead of having two different languages, one for juveniles and then one for adults for expungement.
So your motion, well, go ahead, Brian.
Mr. Chairman, I think there's two ways to approach this. Perhaps on page 2, line 6, after majority, insert the language of 713-1401B and C. And we would probably maybe break that down and window that with some Romanettes. A second approach would be at that same location to insert petitions shall be served upon. Oh, okay. The provisions of Wyoming statute 713-1401B and C shall apply to any petition filed under this section, which might be more concise.
Senator Hicks, your motion was?
I do think that that's probably better actually than bringing in the language, is just cite the statute that it has to be. That way it's consistent. There's consistency through our statutes that way, Mr. Chairman.
Okay, we have an amendment moved. Is there a second? Second. And a second? And who seconded? Representative Jennings, thank you. Discussion on the amendment? And the proposed amendment. Yes, Representative Stith.
Mr. Chairman, on and against the amendment, it seems that one of the big purposes of this proposed bill is to treat juveniles differently and to really wipe out the record itself. So, for example, if you have a kid who gets in trouble when they're 15 or 16, but then a few years later applies to join the military, if you have the same definition of expungement as for adults, then the records are really all still there, and they'll get them. So it seemed like this is a big change if you make the definition of expungement the same for adults as for juveniles. If that's what that's my understanding of what this amendment would do. So if I'm wrong about what this amendment would do, let me know. But my understanding on and against.
Mr. Chairman, if I was, it doesn't change the definitions at all. The definitions for expungement for juvenile, what it does is it establishes process. But the process for a determination by the court or the county prosecuting attorney is the same. So it more deals with the process. It doesn't really deal with whether we're going to change juvenile expungement. It just clarifies the processes when there is a petition before the court. The process that we're going to bring in now is that is described in the statute for adult. We're going to bring that process in. So there's not an and or there's not an or. So the way it reads, satisfaction of the court or the prosecuting attorney. What this process does is now set up and say the prosecuting attorney gets to go to the court and within 20 days of an order, review that, provide additional subsequent information to the court for that determination. So maybe it would be good to reread that statute. So what we're really doing is interjecting process. It doesn't change what we're doing as far as the expungement provisions.
Mr. Chairman, just because I'm obviously confused, I just don't think I understand what the amendment is then.
Could you read this amendment again? Not the amendment, we're just going to add the language, but what that language, how that changes.
Mr. Chairman, just to walk through this fully, the amendment would insert the sentence on page 2, line 6, the provisions of Wyoming statute 713-1401 B and C shall apply to any petition filed under this section. 713-1401 B reads, any petition filed under this section shall be verified by the petitioner, served upon and reviewed by the prosecuting attorney, and no order granting expungement shall be issued prior to the expiration of 20 days after service was made. Mr. Chairman, subsection C reads, the prosecuting attorney shall file with the court an objection, if any, to the petition within 20 days after service. If an objection is filed, the court shall set the matter for hearing. If no objection is filed, the court may summarily enter an order if the court finds that the petitioner is otherwise eligible for relief under this section.
Does that answer your questions, Representative Stith?
And I apologize. Could staff say again, what's the exact reference then that's being inserted? It's 7-13-1401B.
And Mr. Chairman, Representative Stith, 713-1401 B and C.
Okay. So I'll just pull that up here and think about it. Thank you.
Thank you. All right. Question's been called on the amendment. All in favor, say aye.
Aye.
Opposed?
No.
Amendment passes. All right, we're back on the bill.
Mr. Chairman.
Representative Pelkey.
I think you all have copies of the proposed amendment.
And this is the bill with staff comments, that one?
Yes.
Copy of the bill. First page says staff comments.
Yeah.
Representative Pelkey.
That's the guy they're talking about. Yeah. And then the proposed language changes are in those gray boxes. In essence, it simply allows a county attorney, a district attorney to initiate the expungement process without requiring the juvenile, or now the juvenile who's reached the age of majority, to initiate that process. It could be as a matter of policy in some areas that, you know, once they've got a diversion project or program, that they would simply have that automatically taken, or have it taken out at the request of the county attorney.
So your amendment is just to add the new language in the box. It'd be 713-1401.
That, and on page 5.
We want to do them one at a time?
I'd just like to run this as a single amendment.
Okay.
Yeah. Whatever highlighted language, and you can see important note that there is no filing fee. I think that will save counties money for not having to pay a filing fee to initiate an expungement with the consent of the county attorney.
Motion and a second, and that's a two-part or two-page. Really, it's a three-pager, but it's different sections in the bill.
Yes.
the block, and then the new language at the bottom of 5 and 6. Got a motion and a second. Any discussion on the motion?
Discussion.
Representative Jennings.
Mr. Chairman, I'd like to ask a question on K on page 2, line 13. The state may file. How does that work in practicality? Say Albany puts in a policy that they're just going to do this, and say Sheridan is, they just decide they want to pick the nice kids. How does that function?
Well, first of all the nice kids live in Laramie.
That was going to happen.
Well, in essence, I mean, I think had this been a requirement, I think that we trust our elected officials to carry out their duties as they see fit. Certainly, my county attorney has initiated some significant reforms in dealing with juvenile cases, but that's based in Laramie. I'm not one to mandate from the state level what every county attorney should do. What this does is it provides them the flexibility to do it or not.
Chairman.
Yes, Senator.
Question on the amendment. So under this scenario where the state or subdivisions of the state may go ahead and file the petition for expungement, I can envision several scenarios that the person that's record's being expunged is not even aware that the state acted upon their behalf. So how do you, I've got some suggested language to maybe make sure that that's clear. And particularly where you're dealing with the transient student population, is that you could have a misdemeanor violation in one county and graduate and move on, and then the county decided, or the municipality, to act upon your behalf, and you may not ever know that your record was expunged. So I think that's problematic from a standpoint. It doesn't accomplish what you're trying to do, and that's to make sure that these individuals' records are expunged and they're aware of it. So back to the examples of a job interview or any of that thing, you can clearly say, no, I don't have a record. So how do you anticipate, and I've got some proposed language, but that's the first question. How would we know? How would they know?
Well,
Representative Pelka.
Mr. Chairman, there is not a notice requirement, and you've seen that there's not a requirement for notice, so it doesn't put a burden on the county attorney's office to say, as a matter of policy, we're eliminating the record of minor in possession of alcohol. As a matter of policy, all of them are expunged. Certainly there'd be an attempt to notify, but it doesn't put the onus of service on the county attorney's office, and I think it makes it a little bit lighter. But certainly I think that any good policy would require that, you at least make an attempt to notify by mail that, hey, guess what? Your record's been expunged. And you didn't have to do anything because it was a matter of policy in this county to do that.
Yes.
So just to follow up, and I don't want to put the burden of notice on the county. Again, that may not facilitate what we're trying to accomplish here is expungement. So these don't follow an individual into their adult and affect their military service or jobs or careers into the future. So I think it would be better is to say that the state or the municipality may act in behalf on the interest of that person with their consent, because now they're aware that the state's going to do this and that they can then say with a clear mind that they're aware of that my record's been cleared. Otherwise, I still don't think we're getting to what we're trying to attempt here.
Mr. Chairman,
please,
Senator. In essence, that's creating a requirement of notice. I mean, if you're going, in essence, you're requiring that service be in there. I think it would increase the burden on the county. Certainly, I think the more reasonable scenario would be, okay, you're in this office, you're being prosecuted for minor in possession of alcohol. We're going to give you a diversion program, and when you reach the age of majority, 18, it will be cleared as long as you comply with the requirements, and we'll initiate that process. I don't think we're going to have that many people who are unaware of the fact that their county attorney plans on expunging that record in the future.
Senator Hicks.
Mr. Chairman, the way I read the bill, it says is that the state may or the municipality does. It doesn't say we will. So now I'm again confused because based on what you just said, you said through this diversion program, it would say your violations will be, again, this is permissive at the state level.
Chairman,
please.
And again, I didn't want to cause any confusion. It is permissive. But what I'm saying is that as a matter of policy, for example, in Albany County, somebody has a violation as a juvenile, they sit down and spell out the procedure and the process of the diversion program. And at the end of that conversation, early in the juvenile process, they inform them that as a matter of policy in this county, once you've completed all this and once you reach the age of majority, your record will be expunged. It may be different in Carbon County. It may be different in Bighorn, but at least this gives the flexibility to the county attorney to establish a policy and to try to have progressive treatment of juveniles without putting the burden of that child or new adult to file a petition.
Senator Hicks.
Mr. Follow-up. So Representative Pelka, under that scenario, because this doesn't just deal with county records, it deals with municipal records too. You could very well have a county have one policy and a municipality have a separate policy in the same county. Is that not the case? And then don't policies change as county prosecuting attorneys are elected positions. Those policies may be changed, but the issue is it's not a blanket policy because it does cover municipalities too.
Mr. Chairman, that's true. And the alternative would be to mandate this. And I just don't think that the state should require, we're all about local governments, and sometimes you get variations in policy, but this at least allows a county or a municipality to establish a policy and follow it. And if they choose, without a mandate from the state, we're offering them flexibility. But if they choose, without that mandate, to go ahead and offer expungements almost automatically in the fact that they're initiated by the county or city attorney, I think that's the kind of flexibility we should give our counties and our city.
Mr. Chairman, and I don't want to belabor the fact.
Oh, come now.
I'm back to that we're going to tell these juveniles that there's a policy, but they go into the exact same diversion programs whether you come through municipal court or whether you do county court. Then do we explain to them that, especially in counties that have multiple municipal courts within the jurisdiction of the county, I think it creates a lot of confusion. And at some point in time, the intent of this is so these youthful offenders' records are expunged and they're aware of that expungement so they can truthfully say at future opportunities that I have no record. I'm still concerned that this does not get to the issue that they're aware and to make blanket statements of the policy here or there. I just don't think we're getting to the issue of what we really are trying to accomplish with this. I'm all for the expungement. I'm just worried about the actual application of this and what we're trying to accomplish.
Yes, Senator Anselmi.
Thank you, Chairman. And not to belabor the issue either, but one thing that Representative Pelkey is saying is that they have to attain the age of majority. It seems to me that maybe the parents could sign off for them. Say they're 16 and they're a real go-getter and they're going to apply to military school, they graduate early. I mean, why do we have to attain the age of majority? Couldn't the victim sign with their parents to say we want it expunged as soon as possible and be done in that way? It's in the record and moved on versus having it be mandatory, just to address the idea.
Any other comment on the amendment? I do have a concern. I appreciate the direction and the local control. I worry a little bit about the equal application, the outcome where if we use the college scenario, a student who attends the university town could get an automatic expungement, but the student who applies and goes to a community college may not. And then as they go back and forth from that community to their home community, and all of a sudden you have kind of a patchwork of consequences and tracking.
Mr. Chairman.
And where does the location then set up a kind of an unfairness? And then the evolution of that kind of leads us down rather than take it away to make it mandatory statewide.
Mr. Chairman, we have a patchwork all over the state. Depending on what law enforcement agency you get arrested by or charged by in Albany County, for example, will generally determine the outcome of your case. Our municipal court prosecutors are rigid and inflexible at times, and they don't take the same sort of broad view of justice that perhaps the county office does. We'll always have patchworks around this state. All I'm doing is giving the flexibility to those prosecutors. It's another tool in the toolbox, so to say. It gives an incentive for somebody to complete their diversion program with the incentive of having that expungement down the road. But I'm loath to mandate that behavior throughout the state. And so we've got a patchwork already, and we're going to continue to have patchworks because it depends on personalities, it depends on department policies and so forth.
Any other discussion? All in favor of the amendment as proposed? And remember, this is a two-part amendment. Say aye.
Aye.
Opposed?
Opposed, aye.
Aye. Passes. All right, back on the bill. Any other amendments on the bill? How about a vote? Whoops, not yet.
Mr. Chairman, I just point out, given the successful Hicks amendment and this successful amendment, there may be a requirement now that the prosecutor serve notice on himself. I don't know. And that's something that we can certainly work on, the language. I mean, it's a technical thing, and I don't think it's inconsistent. It just would be odd. So I just want to bring that up to the committee.
Perhaps if there's a logical tweak, you could look at that. If it's going to require additional action, and should this bill go forward, we could certainly deal with it in the session. Okay. Does that work? Okay, thank you. And how about the roll call?
Mr. Chairman, this would be a vote for the committee to sponsor 19 LSO 107 draft point 9 as amended. Senator Anselmi Dalton. Aye. Senator Hicks.
No.
Senator Kinski.
Aye.
Mr. Chairman, Senator Nethercott left a vote of aye.
Okay.
Representative Beitman.
Aye.
Representative Jennings.
No.
Representative Olson.
Aye.
Representative Pelkey.
Aye.
Representative Pennell.
Aye.
Representative Salazar.
Aye.
Representative Stith.
Aye.
Representative Winters.
Aye.
Chairman Kirkbride.
Aye.
Chairman Christensen.
Aye.
Just have a moment.
All right, that one passes. We will pick up with the rest of the judicial updates, court security camera after lunch, and we'll be back here at 1:30. Continue on with court security cameras, opioid task force bill referral, and then get into justice reinvestment. Thank you all for spending the morning with us, and we look forward to your presence this afternoon.